speak to it. Why would I do that? I would have just written a letter or something. When I raise an objection, if a witness stands and I say this witness is whatever, I must then say why I'm objecting. Somebody who disagrees with me, like Mr. Jamie.
Mr. Mpofu, can you please close now? Otherwise, I'm going to make an order.
Yes. In other words, I'm not allowed to raise the objection.
No. You have raised it. We have
no, I
noted
have not raised it, my lord. No, Mr. Jamie has correctly put it about noting an objection. That's one thing. I've asked you in chambers and here to raise an objection, not to note it. And that means I raise my objection and it's responded to if it's responded to, and then the court makes a ruling. If the ruling is against me, there's nothing I can do. But I cannot be disallowed from raising an objection.
Mr. Masuko, you're on. Sorry, there's Mr. Masuko on his feet.
Oh, I'm sorry.
My lord, and honorable justices, I appreciate the concerns that we all have with time. My client is here because there is an interdict sought against him by the DA and Corruption Watch. That is the reason why my client is here. That is why, even though we've dealt with the basis on which this interdict is sought, essentially dealing with what FUL wishes to raise, it's a procedural oddity, it's a procedural absurdity. To have a final order, an application to have a final order granted in circumstances where the primary litigants of the case, which was the DA and the Corruption Watch, brought to this court an interdict against my client. Now we have to listen to an argument on part B of the application. Mr. Mpofu is correct. I'm quiet because I'm thinking, well, for good order, I'm going to deal with it at the end of the case. But the more I think about it, it's important that this objection is noted. And the objection is a simple one. Why are we hearing a matter on part B, which relates to the lawfulness of the National Assembly's designation of Dr. Hlophe as a member of the JSE? First, when there's an interdict that's being sought against him, which was the very interdict on the basis on which our client came here.
Yes.
So I'm not going to stand up again. This is what I would accept if the court said we should just go ahead and argue everything.
Yes.
But this objection is valid. It should not be poo-pooed and be regarded as a waste of time. It is not a waste of time.
Yes. Thank you. I'm going to make an order now. We've got to, because we are losing time, and that's going to derail this whole hearing, which is set down for 2 days. There is no disallowing any objection, but remember this, it's for this court to decide that issue.
Yes.
Yes, not anybody else.
Yes.
However much you may think it's out of order, improper, or whatever, or it's bizarre, let's let that. We note that. Counsel's thinking, and counsel will support their views in that regard. At the end of the day, it's this court that's going to decide what to do about that application. If it was wrong and it shouldn't have been there, appropriate orders will be made by this court. The council shouldn't just push their way now into, we don't think this should carry on, and so on and so forth. We've made an order about how these proceedings should carry on. And in the interest of everyone, whether it's Mr. Masuku, Mr. Jamie, or Mr. Mpofu, they must have their time to inform this. And why I set out the background to how it has happened, it has not been created by this court. We found it here, and we've got to deal with it and give a judgment in that regard, or an order, whatever we've got to give. Now, for counsel to come and be addressing us about how improper it is for this, yes, let's say it is, maybe, in your view, and that's your view, and you're entitled to it, and you're going to have time to tell us about it. But now to stop this court from carrying on with business of the day, including your business of the day, is not going to. This court has got a duty to make sure that this case proceeds and it gets finalized with the time allocated. and we'll hear all your views in that regard in your time that is allocated. Now, what is happening is that if you allow you further time, Mr. Mpofu, that's going to derail even your case, your interest in terms of time.
No.
And we are saying, we've heard you, you're entitled to your views, but let's not now push these proceedings aside in a manner that's going to derail everybody. So I've asked you to close,
Yes.
and then address.
Yes. Then let me then say this, only this, Madam. The tone of what Your Lordship is saying suggests that raising the objection is in itself wasting time. But Your Lordship then has not listened to what I'm saying, because I'm saying raising the objection is an exercise in saving time, right? In other words, what I'm saying is that if we are going to hear a case that could have been happening next door in another court, exaggerating for effect, then that is an exercise in wasting time, because it's like calling someone walking in the street and say, come and address the court. Because we're saying these parties are not before the court. That's a crucial thing, my lord. The court might take the view that that's wrong, but that's a different thing. But the court cannot disallow us, with the greatest of respect, from raising an objection and label it as all these negative things. Because we have clients, it's not me, and you're referring to me, it's not me. I have instructions from a client. I've got nothing to do with this. And my client has insisted that I have to say that to save the time, so that we can have enough time, all of us, to ventilate the issues. Let's not invite people walking in the street and who have raised other cases. And
you are saying FUL is a party walking in the street?
In terms of Part A, definitely. They have not brought a Part A application before this court.
We have heard you, and the decision of this court and the ruling of this court, Mr. Mpofu, is that we are going to hear that application, and that we've noted your objection. And yes, you may.
That's the court, please.
May I note that we started 29 minutes late?
Yes.
My learned friend, Mr. Tukasi, and I will share our submission. The issues that I will address are the following. I will firstly look at the requirements for a designation of members of the Judicial Service Commission in terms of Section 178(1) of the Constitution. I will then address the facts of the manner in which this designation was done. And you will know, but I will just emphasize that it was done by deferring entirely to the opposition's nomination of 3 candidates. We will then submit that that method, whilst that method may be perfectly legitimate for the purpose for which it was created, namely to determine the composition of parliamentary committees, it is entirely inappropriate for purposes of the designation of members of the Judicial Service Commission. It's inappropriate for 3 main reasons. Firstly, because it means that the National Assembly did not exercise any discretion at all. It didn't make a choice. It passed the buck to MK. That is classically unlawful decision making. It secondly failed to make its choice in the public interest. It simply passed the buck and didn't pursue the public interest. And in the third place, failed to make its choice as it is required to do in terms of Section 165(4) of the Constitution, in a way that protects the courts to ensure their independence, impartiality, and dignity. I will lastly say something about the standard of review and the court's jurisdiction. The suggestion, in other words, that this court doesn't have jurisdiction because this is a matter within the exclusive jurisdiction of the Constitutional Court. We will submit that is not so. As for Mr. Mpofu's objection, I will address it in reply. Let me just say, we are not here participating in anybody else's application. We are here with our own application for a final order. It so happens that it's been convenient and agreed by all that this application be heard together with other applications of other people who seek interim relief. But our application is a freestanding application for final relief. It's a stock standard conventional application for final relief, and the suggestion to the contrary is completely unfounded. Let me then start with the requirements for designation under Section 178(1). Now, it's important to note that it is not only Parliament that designates, but there are a number of other functionaries under Section 178 who are given the power and responsibility of the designation of members of the Judicial Service Commission. May I just go through them very briefly? It's firstly 178(1)(c), designation of one judge president by the judge's president. And then 1G, designation of a teacher of law by the South African universities. And then follows the National Assembly in H, designation of 6 persons designated by the National Assembly from among its members, at least 3 of whom must be members of opposition parties represented in the National Assembly. I emphasize that it's not a nomination by opposition parties. It is a nomination by the National Assembly, of whom 3 of the 6 must be members of opposition parties. And then lastly, J, designation by the President of 4 persons designated by the President as head of the National Executive after consulting the leaders of all the parties in the National Assembly. Now, we submit with respect that it is clear as daylight that what the Constitution does is not only to give these people a power of designation, but it's also a responsibility of designation. It means that the functionaries identified and trusted with this power must at least do 3 things. They must at least make a careful choice. They must consider, they must ask themselves, is this candidate suitable for appointment? I'm not going to address you on the precise standard that is required, but there must at least be a discretion exercise, thought given to the question, is this candidate suitable for appointment? Is the candidate capable of doing the job? Is the candidate someone whose participation in the appointment of judges will instill confidence in the public mind about the manner in which judges are appointed? So, because that is what the responsibility of designation means. You must make a choice. We trust you to make a choice. But it doesn't mean that you can make a random choice, or throw a dice, or ask your friend, or ask anybody else what to do. You have to exercise that, a careful choice, to determine whether it is a suitable candidate, to determine whether that nomination, that designation, is in the public interest. And then in the third place, do it in accordance with Section 165(4), to which I shall return. What are the facts of this case? What happened was that Parliament, the National Assembly, did not have a specific process designed for designation. So what they did, and I'm not blaming them, but it was a big mistake. What they did was to use the procedure they follow when they constitute parliamentary committees. Now, clearly in those parliamentary committees, it is important that there be representation by all the parties. And for that reason, although the National Assembly formally appoints people to those committees, they allow the parties to nominate their own candidates and then they rubber stamp them. Perfectly sensible procedure for that purpose, for purposes of constituting parliamentary committees. But the Judicial Service Commission is not a parliamentary committee. And the purpose there is not to have individual people represent various political parties. They are there to represent the National Assembly and vicariously are there to represent the public. And that is why there is a big responsibility on each of those people who make the appointment to do so carefully and in the public interest. Now, as far as the procedure that was actually followed, if I may refer to the following parts of the papers in which that procedure is described, and you'll see that what it is they simply followed the procedure used for the appointment of parliamentary committees, and in doing so, followed the convention or the habit that they have developed in Parliament of simply endorsing the nominations by the various parties. Firstly, in the Speaker's answer at page 505-6, paragraph 7, she says, I wish to emphasize at the outset the complexity and uniqueness of this particular nomination and designation of members of Parliament to the JSC. She makes a valid point. It's a new process. We didn't have a standard procedure for it, and that is why we made do with other ways, with the way in which we normally constitute parliamentary committees. There followed a debate, and Mr. Shabambu of the EFF, then of the EFF, spoke at 05-24 in paragraph 48.3.3. And in the course of his speech, at page 05-25, he said the following. So, let us respect the fact that a certain number of people in South Africa voted for the MK party and have designated Dr. Hlophe to become a member of Parliament. And here's the important part. So let us respect that. It is a matter of protocol which we have always protected in the Chief Whip's Forum for that whatever is designated by a political party must be respected. So we will wish you well, Dr. Hlophe, in the JSC. Making the point that we endorse whatever the parties nominate. The same sentiment was expressed by the ANC's Chief Whip at page 05-29 in paragraph 53. And that is important because other people later confirmed that that was the process they followed. He said, Madam Speaker, there are just 2 or 3 issues we want to raise on this matter. The first one, that it is correct that the Chief Whip's Forum, we have agreed to work within certain parameters. We have established certain principles. One of those principles is that parties must be permitted to second their own chosen members to specific portfolio committees. That's one of the principles that we have established. It doesn't mean that there would not be a time when we would deviate from that if there was a concern emanating from one of the parties. And then I skip a sentence and it says in the underlined bit, but our own view as ANC, which is a view that has been consistent in all the committees we have said, the Chief Whip's Forum as well as the Rules Committee, we have agreed that in substance, instances where the rules of Parliament, the Constitution, has not clearly defined a particular position, we are going to have to live on the basis of the established rules and practices of Parliament. So we agreed with Mr. Shabambu that the practice for the appointment to parliamentary committees should be followed. MK agreed with that description of the process in its answer at 06-25, paragraph 60. It says the following. The applicants themselves have conceded that there is a convention, custom, and/or long-standing practice which freely permits a political party to designate any of its members to any outside forum, such as the JSC. No valid reason has been advanced for deviating from this salutary practice in the case of the JSC. Next paragraph. More significantly, it is common cause that the Chief Whip Forum, all parties, including the DA, adopted an unwritten rule granting total and undiluted autonomy to political parties in the selection of their own representatives. Let's listen to this. This is now a function that is meant to be performed by the National Assembly. But what they did was to adopt or apply a rule granting total and undiluted autonomy to political parties in the selection of their own representatives. And then over the page at 06-26, paragraph 66, second sentence. Firstly, the rule granting political party autonomy is perfectly rational, unassailed, and well established. And then at page 0641, paragraph 141, he endorses the description of the Chief Whip of the ANC of the process they followed. So it's clear, it's common cause that the process they followed was to allow MK to nominate 3 people, which the National Assembly then endorsed. And they endorsed it not because they agreed that those 3 people were good candidates. They endorsed it because they have a convention in the appointment, in a different process, in the appointment of parliamentary committees. They have a convention of recognizing what MK calls party autonomy in making those nominations. So they
in the absence of procedure that was in place at the time, what were they required to do?
Well, they were required to consider whether the people nominated are suitable and the best candidates for the job. And lady, one shouldn't assume that they had to have a set procedure for making these nominations. If they didn't have a set procedure, then they should have followed an ad hoc procedure. What they were not allowed to do is to adopt a procedure designed for a different purpose, unsuited to this purpose. I submit with respect, I will now deal with the qualities that the manner in which they ought to have exercised that power. But the one thing they were not allowed to do is to adopt a process designed for a different purpose, which is unsuited to this one. Let me turn to what we submit they were required to do. Each person, each entity empowered to make a designation must in the first place exercise its own discretion. It's easier to understand if I use the example, for instance, of the President. The President is empowered to designate 4 people. Now the law requires that choice to be made by the President. It would be unlawful for the President to ask someone else, his PA, or his friend, or a cabinet colleague, to give him 4 names and simply to rubber stamp. The President must exercise a careful and responsible discretion to assess whether the candidate is suitable and appropriate for appointment. If the President exercises that discretion, the courts will obviously show a great deal of respect for that discretion and wouldn't readily overturn it if it is properly exercised. But the first requirement for the exercise of any public power is that the holder of that power must exercise their own discretion. And in this case, it means must themselves think about it, ask themselves whether this is an appropriate nomination. If I may refer in this regard to...
Before you make that reference, Mr. Chenko, this is not the first time that Parliament was designating people to the JSC. That is common cause. And I suppose in that practice, which is common cause, a precedent had been set of applying the same procedure, let's call it the portfolio committee procedure, to the designation procedure. And it has happened without incident. And of course, one doesn't have to think hard as to why it has happened without incident. We have a first-time situation of an impeached judge sitting in, falling into the category of 6. Now, when people follow precedent, as we do in our law, can they then be said to be acting wrongly, unlawfully, or improperly, or irrationally, and all those?
Let me just say, I'm not clear about the manner in which the National Assembly have previously exercised this designation power. I suspect that you are correct, but what they tell us is that they didn't have a procedure, they didn't have a set procedure for purposes of this function. And the Speaker tells us that this was a unique occasion. So whatever might have happened in the past, it seems that they recognized in these circumstances that there was no prescribed procedure, and they then used the procedure employed for the constitution of parliamentary committees. But let me accept for the moment that they probably did so, that they've probably always done so. Well, then they have always acted unlawfully. An unlawful exercise of a public power doesn't become lawful because you've done it many times. It might make it humanly understandable, but it doesn't make it lawful. Take the very first requirement for the exercise of a public power. The holder of the power must herself or himself exercise that power. You can't defer to anybody else. You can't pass the buck. And that is the principle to which I propose to refer you. In the case of Minister of Environmental Affairs, the Cinematic 14, it's 2005, Volume 6, SA, 182, SCA, paragraph 20, where the court said, in paragraph 20, a functionary in whom a discretionary power is vested must himself exercise that power. And then they cited with approval from the case of Hlophe, the Minister of Justice, where it was said, it is well established that a discretionary power vested in one official must be exercised by that official or his lawful delegate, and that although where appropriate he may consult others and obtain their advice, he must exercise his own discretion and not abdicate in favor of someone else. He must not, in the words of Baxter, quote, pass the buck. And then further on in the same paragraph, what the functionary may not do, of course, is adopt the role of a rubber stamp and so rely on the advice of others that it cannot be said that it was he who exercised the power. In making a decision, he would, if in making a decision he were simply to rely on the advice of another without knowing the grounds on which that advice was given, the decision would clearly not be his. And that's exactly what happened here. Precisely the way in which the courts have held the decision may not be taken was the one adopts it here. So the first fatal flaw is that the National Assembly did not exercise its discretion at all. It acted as the President would when he asks a friend to give him 4 names. That is what they did. And it doesn't matter whether they understandably did so, maybe they did. It doesn't matter that they might in the past have done so, maybe they did. But it was blatantly illegal. The second requirement for the exercise of any public power is that it be exercised in the public interest. And that really speaks for itself, but if I may just in this regard refer to the case of the Sussman Foundation, the Judicial Service Commission, 2018, Volume 4, SA 1, Constitutional Court, in paragraph 37, where Justice Madlanga said the following: I do not think it unreasonable to expect that those that bear the responsibility of nominating, designating, or electing individuals for membership of the JSC will take their responsibility seriously and identify people who are suitably qualified for the position. Well, that is what the NA didn't do. They didn't apply their minds. They didn't ask themselves, are these people, did they seriously ask whether these people are suitably qualified for the position? They didn't do that. They said, well, these are nominated by MK, and according to our convention, we will simply rubber stamp the MK nomination without considering whether it's a good idea. Then the third requirement is that it be exercised in accordance with Section 165(4). The section reads, organs of state, through legislative and other measures, must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. Now, one doesn't even need to contemplate exactly how that duty should have been discharged in this case. But what it does do is simply to accentuate that these functionaries entrusted with these public powers were required to ask themselves whether the manner in which they exercise the power accords with Section 165. They must ask themselves, does this nomination assist and protect the courts to ensure their independence? Does it instill public trust in the appointment of judges, which is so important for the rule of law? Well, there's no debate about it. The National Assembly clearly did not do so because they didn't think about it. They followed and rubber stamped the MK nomination.
Well, say for the argument by the respondents that says, yes, they did think about it to the extent that they recognized Dr. Hlophe as a well-educated person in law and a person who had had previous experience in the JSC appointment processes, and therefore who had appropriate experience, appropriate education, who had been a judge for a number of years, and so on and so forth. So that's how far they're thinking about it. Well, that's the respondents. I'm just putting that. That's how far they thought about it. So you can't say they didn't think about it. They thought about it, but maybe not to the extent that you did.
If I had said that we gave it serious consideration, we saw that it was a highly learned man, we respected him as a leader, we took account of his impeachment, but it didn't, in our view, disqualify him, it may have been a different matter. But they don't say that. What they say today is we rubber stamped the nomination then, because that was our convention. And then they come up and they say, but it is a good appointment. Here are all his qualities. My learned friend, Mr. Kassi, will address you on the question whether that was a rational and a reasonable decision. But we must make it quite clear that nobody says that those were the considerations that moved us to make the designation in the first place. All of them agreed that they simply rubber stamped the nomination, and now in the papers say it was a fair nomination.
So you are saying the real reason was the convention.
Oh yes.
Everything else is an afterthought.
Yes, and I'm not criticizing them from defending or seeking to justify the appointment today, because there is another debate, the one that my learned friend Mr. Kassi will address you on, to say that whether they thought about it or not, the outcome is an irrational and an unreasonable one. So all of those factors are relevant. But relevant only to the rationality and the reasonableness. The decision was fatally flawed even before you get to rationality. It was fatally flawed because the organ of state vested with the power of designation didn't make a choice, made no choice at all. They rubber stamped a nomination by MK. May I say something briefly about the standard of review and about jurisdiction? We submit with respect that this decision is subject to review under Paja. But even if we're wrong, then it's reviewable under the doctrine of legality. And let me say about Paja. Some of the other parties make the point that this is a legislative body and therefore their decision is legislation and not administrative action. But that's not so. This is an administrative decision vested in a legislative body. But they don't make law where they designate people. They exercise, in other words, if you compare them with the designation by the President, nobody would suggest that that's legislation. The function performed by the National Assembly is exactly the same as that of the President, of the law teachers, of the judges president. It's an administrative function. And in Paja itself describes administrative action as any decision taken or any failure to take a decision by an organ of state, and I skipped some words, which adversely affects the rights of any person and which has a direct external legal effect, but does not include. And then what is significant in that exclusion, those exclusions, in DD, they exclude the legislative functions of Parliament, a provincial legislature, or municipal council. They didn't say we exclude the functions of the legislature. They excluded the legislative function. So when a legislature takes an administrative decision, it is still subject to Paja. But if we're wrong, then it is executive action subject to review under the doctrine of legality. Lastly, on jurisdiction, the ATM particularly has much to say about it. What they say, they argue that this the determination of the lawfulness of this designation is exclusively within the jurisdiction of the Constitutional Court, because Section 172 gives it exclusive jurisdiction in the determination of the question whether Parliament has discharged the constitutional obligation, has fulfilled the constitutional obligation. Now, the Constitutional Court held in the EFF case, that in the Nkandla case, that is EFF, the Speaker of National Assembly, 2016, Volume 3, SA 580, paragraphs 15 to 20, that jurisdiction must be narrowly defined. And you must ask yourself the question whether the obligation we're talking about is one which is agent-specific. In other words, it is an obligation which is specifically imposed on Parliament. Now, our own friends argue, yes, well, the function of designation is specifically entrusted to Parliament. But that is not the point. The case is not here whether they made a designation or not. The question, we know that they made a designation. The question here is whether that designation was lawfully made. Was it made in accordance with Paja? Was it made in accordance with the doctrine of legality? Those are stock standard generic obligations. There's nothing agent-specific about it. And let me give this example. If Parliament enacts a piece of legislation, an act, which is unconstitutional, it is discriminatory or whatever, Parliament enacts legislation, the legislation is discriminatory. It is a stock standard application for an applicant then to come to the High Court to attack the legislation. It is true that the function of making legislation is a function exclusively entrusted to Parliament. But the duty which was not fulfilled, the obligation that was not fulfilled in this case, is the generic obligation to exercise administrative and executive powers lawfully and not rationally and reasonably. So that while it is true that this case concerns designation by the National Assembly, the obligation which the National Assembly failed to fulfill was the obligation to take its decisions in accordance with the standards of administrative law. And that is a generic obligation and not one specifically imposed on Parliament. Thank you, my Lord and Lady. Those are my submissions. My learned friend, Mr. C. will take over, please.
Yes, Mr.
Thank you, Justice Bucko. I was wondering whether there's going to be a tea break, but I'll continue immediately.
I'd rather know because lost time.
We're very happy. Justices, Mr. Trengrove has shown that the facts before this court demonstrate that when it did so. He has dealt with those grounds of review. It falls for me to deal with the next two review grounds: the failure to act rationally and reasonably, the first one, and then the manner in which the National Assembly ignored relevant considerations and embraced irrelevant ones. But if I might start, with your leave, Justices, just highlighting what we respectfully submit are governing and clarifying principles of review, because they keep the case, we say with great respect, simple. And for all of the plethora of defences that have been raised by Dr. Hlophe and Mr. Zuma for the MK, the case, we say, remains simple because of those critical principles of judicial review, and each of them, as you will see in a moment, have been stressed by the Constitutional Court and the Supreme Court of Appeal. I don't need to go into them in any great detail. We've raised them in our heads. But I highlight that we've not heard a word from our learned friends in response to these principles in their heads of argument. They've not contested with them, they've not grappled with them. And that is, with great respect, telling, because they don't have an answer to those principles. Three principles stand out. The first principle is this, and for shorthand, I'm going to call it the Similane principle. It dealt with the decision by the President to appoint Mr. Similane as the National Director of Public Prosecutions. It's in our heads of argument in the Democratic Alliance case versus the President of the RSA. And that principle is the following. It says that for a decision maker, particularly in an appointment process, to act rationally, then the decision maker must do two things. Firstly, it must consider properly all the relevant considerations, precisely to ensure that the purpose of the statute is met. And secondly, and critically, it must explain with proper reasons why it overlooked critical principles that are material to its decision. And the principle works like this in this case, Justices. The decision-making process adopted can render the entire decision irrational if it ignores information that was obviously relevant to the fulfillment of the legitimate government purpose in issue here, which was appointment of people to the JSC. And here we say with great respect that the National Assembly failed to consider properly the serious findings that had led to Dr. Hlophe's impeachment and would obviously have destroyed public confidence in the JSC. So we say in the first place that the Constitutional Court's decision in Similani make this court's task easy in confirming the unlawfulness, because the Constitutional Court said it clearly in Similani, dealing with an appointment process, and it did so through the lens of rationality. It said that if you fail to consider that consideration, then it has a fatal effect. It colors the entire process as irrational. So it may be that there were other reasons. There may be precedent or practice or past manners in which the appointment was done. That's an irrelevance if there is a failure to consider a serious and proper consideration in the form, for instance, of Section 165.4. So that would render the entire process unlawful. And with respect, the Similani judgment is important for another reason. We have heard references to separation of powers, and Dr. Hlophe and Mr. Zuma tried to argue that the decision by the National Assembly has to be respected because of some form of deference that the court owes to the National Assembly. But with respect, deference doesn't enter into the picture. The Constitutional Court has shut that line of argument down, and it did so again in the Similani judgment. You'll recall there it faced the same contentions. There the argument was, but Mr. Zuma's decision to appoint Mr. Similani should be respected, and the court should show deference to that decision. But the Constitutional Court said that that argument was entirely misconceived. It did so at paragraph 44 of the Similani judgment. Judges, I'm assuming you have all of those cases available. I don't need to take you to the case lines reference. But at paragraph 44 of Similani, this is what Justice Yacoub said. He said their argument was entirely misconceived. Rationality, which is what I'm dealing with, does not conceive of differing thresholds. The separation of powers, said Justice Yacoub, has nothing to do with whether a decision is rational. In these circumstances, the principle of separation of powers is not of particular import in this case. Either, he said, the decision is rational or it is not. And that has been further confirmed in a judgment, or referenced, I should rather say, in a judgment, I think alleged Justice Collis was in the matter. It was dealing with Zimbabwean exemption permits. It's the case of the Helen Suzman Foundation versus the Minister of Home Affairs, which, of course, Justice Collis will know well. And there it was said by that court, in paragraph 146, that they disagreed with the assertion that separation of powers would prevent a court from dealing with a review, because where there is an unconstitutionality, the court has a duty to grant just and equitable relief. So the Constitutional Court, Justices, has made it clear that separation of powers and deference play no role in a review for rationality. And what that means is that if the National Assembly didn't exercise its discretion properly, or at all, in the way that Mr. Trengrove has highlighted, or it acted irrationally, for instance, in ignoring what was a palpably relevant consideration, well, then no amount of alleged deference can rescue it from that unlawfulness. The courts have a duty to declare it irrational and unlawful. The second principle is this. It's what I'm going to call the Rustenburg principle, and it comes from a decision of His Lordship Mr. Justice Cameron in Rustenburg Platinum Mines. It's in Freedom Under Law's heads of argument at paragraph 49, footnote 51. And here I'm just going to lift out the relevant passage by Justice Cameron, where he said this: bad reasons cannot provide a rational connection to sustainable outcome, nor does Padger oblige the court to pick and choose between the reasons to try and find sustenance for the decision, despite the bad reasons. Once the bad reasons, said Justice Cameron, played an appreciable or significant role in the outcome, then in my view it's impossible to say that the reasons given provide a rational connection to it. So the rationale is the same really as in the Similani judgment. It's that if there's a failure properly to take into account a clearly relevant consideration, or there's a failure to properly exercise a discretion at all, in the way that Mr. Trengrove highlighted, then that colours the entire process as bad. It doesn't matter that there may be other reasons, and it's not for you as the court to try and look for them. The third principle is this. It's what I might call the Zuma principle. We've explained in our heads that decision makers are bound by the contemporaneous reasons that they've provided for their decisions. Mr. Trengrove, in a debate, I think with Justice Buckley's touched on some of that. Let me just say to you that the cases from the Constitutional Court, the SCA, the full courts and various divisions have made that point repeatedly. We've set it out in our heads at footnote, it's at paragraph 47 of our heads, and we have set out all of those in footnote 100. It's snapshotted perhaps best through the Supreme Court of Appeals decision in the Zuma case, which you'll see quoted in footnote 48 of our heads. There, the SCA said this, and I'll just read it to you because it's so strikingly helpful in relation to what we know are the reasons that the Speaker gave in the Speaker's 9 July letter. This is what the SCA said. It said, on 6 April 2009, Mr. Mshe announced publicly that he'd made the decision to discontinue the prosecution of Mr. Zuma, and he issued a detailed media statement providing the reasons for the decision. And then this is what Justice Nafsa said for the court. He said, it is against those reasons, and those reasons alone, that the legality of Mr. Mshe's decision to terminate the prosecution is terminated. What does that mean in this case? It means that the National Assembly's reasons are captured in the Speaker's letter of 9 July and in the National Assembly transcript that Mr. Trengrove has already taken you through.
Excuse me, Mr. Aditya, can you just get it straight? I think also for my colleagues' benefit, you referred to paragraph 47 and then footnote 100, but it must be footnote 47. Footnote 48.
48. It may well be my mistake.
That is a case of the Zuma versus the
Yes, footnote 48. Thank you, Justice. That's absolutely right. Footnote 48, and it's at case lines 13-18, to be absolutely specific. Thank you. What does that mean in this case? As I'm saying, it means that the National Assembly's reasons are captured in that letter that the Speaker issued of the 9th of July. And in the transcript of the debates that Mr. Trengrove has really highlighted in the National Assembly. And we have the added benefit in this case that the Speaker commendably has filed an affidavit to say she recognizes her duty to assist the court. And I'm going to just give you paragraphs and then quote them briefly to you. They're in paragraphs 11, 12, and 14.4 of the Speaker's affidavit. 11, 12, and 14.4, and that's at case lines 05-7 to 05-8, where the Speaker said, as I say commendably, she said she's put before the court as her obligation all the factual and legal details necessary for this court to issue a just and equitable outcome, including, and I'm quoting, what transpired with regard to the designation of Dr. Hlophe. So the court knows that all the facts are before it, and it knows that those are where the reasons are to be looked for. It means that the National Assembly cannot renovate or create new reasons, and it hasn't, as I say, commendably sought to do so. But there is a separate and important adjunct. It means that Dr. Hlophe and Mr. Zuma, who are not even the decision makers, they cannot add to the record. They cannot add to the reasons or take away from them. Those renovated reasons, with great respect, are a legal irrelevancy. So with those principles in place, with great respect, we say they are guiding and binding principles that are helpful. I turn to the review ground of irrationality and unreasonableness. In the Speaker's letter of the 9th of July 2024, the National Assembly recorded that it had only considered, and you've heard this from Mr. Trengrove, the express wording of the power to designate 6 of its members to the JSC in section 178(1)H of the Constitution. And the Speaker then stated that there were only 2 requirements in law. First, that the person to be a member of the Assembly must be a member, and secondly, that half of the persons so designated must be drawn from the opposition benches. And then the Speaker's affidavit says there are no further criteria. Well, with great respect, it is wrong, we say, to say that there are no further criteria. In law, there are. There is always the duty to act rationally. And if it's a Padgett decision, there is always the duty to ensure that your decision is reasonable. Because we know that all public power, whenever it is exercised, must be exercised rationally. And we know from the Similani decision that when it comes to the appointment of an official to a constitutional structure, in that case the NDPP's office, in this case the JSC, then both the process by which the decision is made and that the decision itself has to be rational. And we know that the entire process can be coloured as irrational if there is a mistake within it. So the overarching purpose, one then has to step back and say, well, what is the overarching purpose of the composition of the JSC? The overarching purpose of this JSC is to safeguard judicial independence and to ensure public confidence in the appointment process of judges. So, in a word, it is to ensure a legitimate judiciary in the eyes of the public. And that happens in two ways. Firstly, only suitably qualified persons may be appointed as judges. So, the JSC's commissioners must assess and decide on suitability. Yet, with great respect, Dr. Hlophe cannot achieve that goal with his presence in the JSC because he has found, or been found, to be unsuitable, not just unsuitable, but grossly unsuitable. And so his position on the JSC means that the JSC itself cannot achieve the purpose of appointing fit and proper candidates. Second, it's the process problem, it's the public perception problem, and the sanctity of the judiciary within that process. The JSC process must contribute to the moral authority of the judiciary and must enhance the public's confidence in the appointment of our judges. Yet, and here again we say with respect, Dr. Hlophe's presence on the JSC cannot achieve that goal either, because a disgraced judge who participates in the process of a judicial appointment demeans the process. It lowers the stature of the JSC and the judiciary that it's meant to serve. And so we thus, with that proposition, submit that the National Assembly's designation of Dr. Hlophe was not just irrational, it was deeply so. And here that brings me directly to the Similani judgment. We say the present case is analogous to Similani. And in that case, the President's decision to appoint Mr. Similani was held by the court to be irrational because the President had not considered clear evidence that Mr. Similani was dishonest and therefore not suitable for appointment. This is what the court said at paragraph 89. Again, I shan't take you to the passage on case lines, but if you just listen to it and write down that it's from paragraph 89. The court said the President's failure to consider that evidence was wholly inconsistent with the end sought to be achieved, namely the appointment of a national director who is sufficiently conscientious and has enough credibility to do this important job effectively. The means employed accordingly colour the entire decision which falls to be set aside. Now, Justices, the Speaker has gone on to say in her reasons that in this context, in her letter she said on 9 July, it should be noted that there's no specific requirement, said the Speaker, that a Member of Parliament be fit and proper. And the respondents predictably have latched onto that to say, well, the Constitution doesn't require a suitability requirement. But with great respect, that is flat wrong for two Constitutional Court decisions making it so. The first is the decision that my learned leader, Mr. Trengrove, referenced. It's the Helen Suzman Foundation decision of the Constitutional Court, and he read to you from it where the Constitutional Court made it clear that when we talk about appointment of candidates to the Judicial Service Commission, given its critical role in the appointment of judges, it is expected that suitable, that's the word that the Constitutional Court used, suitable candidates will carefully be selected for that particular body. The second decision that puts paid to this idea that there is no...
Excuse me,
yes.
You're referring to that paragraph 37 now?
Yes.
Can you go to that paragraph?
Yes.
You say that suit the... I'm not sure whether the wording that you've just referred to is stated in that paragraph.
The suitability is clearly expressed. So it says this, bearing in mind the importance of this function, Justice, in other words, the function that the JSC plays, where the court had said just previously it plays a crucial role in our constitutional democracy. It said, I do not think it unreasonable to expect that those that bear the responsibility of nominating, designating, or electing individuals for membership of the JSC, in other words, the National Assembly, will take their responsibility seriously and identify people who are suitably qualified for the position. The next judgment that makes it clear that suitability here means appropriately qualified is again the Similani judgment. In Similani, the argument was that the Constitution doesn't expressly say, when it talks about Section 179, that the National Director must be somebody that is suitably qualified or fit and proper. And this is what the Constitutional Court said in Similani at paragraph 13b. The Constitutional Court said, Section 179 obliges national legislation to ensure that DPPs are appropriately qualified. There was some suggestion on the basis that Section 179 makes a continuous distinction between national directors and other directors that the Constitution does not require the national director to be appropriately qualified. Said the court, I'm prepared to accept that the reference to directors being appropriately qualified may be construed as a reference to directors of public prosecutions and not the national director. But then, here's the critical paragraph. The court said, all this means is that the requirement that the national director must be appropriately qualified is not expressly stated in Section 179. This cannot mean, said the court, that the Constitution does not require the national director to be appropriately qualified. That proposition, in my view, simply has to be stated to be rejected. The Constitution, by necessary implication, requires the national director to be appropriately qualified. So, Mr. Trengrove made the point to you that we don't need to fasten on to exactly what suitability means, but that somebody needs to be suitable and appropriately qualified is obviously implied through the Constitution's import that it gives to such an office, and to the importance of ensuring that the persons appointed to such office can fulfill their duties properly. And in this context, we, with respect, submit that Dr. Hlophe's conduct as a judge, by virtue of his impeachment, destroyed confidence in his ability properly to perform that function. He clearly could not, by virtue of his impeachment, perform as a suitable candidate in that particular role. I can deal very briefly with the next round of review, which is related. That's unreasonableness. Mr. Trengrove has highlighted that it's not just a legality review, but it's also a patent review. The moment that is so, then the National Assembly also had to act reasonably. And in this place, we have highlighted in our heads that the National Assembly failed to consider whether there were less restrictive means of achieving the purpose of the JSC. In other words, whether there were any alternative candidates that could have been proposed by MK or another minority party, which may have better been able to foster public confidence in the JSC and therefore the judiciary. I turn now, Justices, to the final review ground, and that's relevant and irrelevant considerations that Friedman law relies on. Let me start with the relevant considerations that were ignored. We've set out multiple relevant factors in our founding papers, and in particular, Mr. Trengrove has already touched on one, but in a different context, 165.4 of the Constitution and the importance of ensuring that the judiciary's function is respected and protected and that it can have relevant independence. For my purposes, I merely need to highlight the following obviously relevant considerations that were glaringly ignored. The first is, and the overarching problem, is that Judge Hlophe had been impeached, not just for gross misconduct, but for gross misconduct of an egregious kind. As noted by the full court in Gauteng, and we've set this out in our heads at paragraph 22, when choosing judges, the JSC acts as the selection panel of the nation. So when considering who that selection panel is, an obviously relevant consideration is the type of person who sits on the panel. And when it comes to selecting judges, it is screamingly relevant with respect to consider not only that Dr. Hlophe was impeached, but also to be reminded of just how serious that gross misconduct was and had to be in order for that impeachment to be finalized. In this regard, again, the Constitutional Court's decision in Similani is helpful. This is what the Constitutional Court said. in Similane at paragraph 52. Remembering there is the analog reports in this case by the Judicial Conduct Tribunal, the Portfolio Committee's decision that the National Assembly had before it. Listen to these words from the Constitutional Court at paragraph 52 in Similane. It said this: "These extracts from the report of the Ginawala Commission ought to have been cause for great concern. Indeed, these comments represented brightly flashing red lights, warning of impending danger to any person involved in the process of Mr. Similane's appointment to the position of National Director. Any failure," said the court, "to take into account these comments, or any decision to ignore them and to proceed with Mr. Similane's appointment without more, would not be rationally related to the purpose of the power, that is, to appoint a person with sufficient conscientiousness and credibility." So, the red lights flashing theme in an appointment process for persons involved in that process has been made clear by the court. And in this case, there were three red lights that were flashing for the National Assembly, and they were flashing brightly red as well. And on each of the occasions, the National Assembly drove straight through. The first red light is this: it's the importance that our own courts have expressed in relation to these types of actions by Dr. Hlophe and their consequences. The most helpful is the Supreme Court of Appeal's decision of last year in Freedom Under Law versus the Judicial Service Commission and another. And I'll give you the citation. It's 2023 ZASCA 103. And this is at paragraph 1. This is what Justice Connon had to say about precisely this case and the processes involved. He said this. He said, "Judicial independence is so critical to our democracy that removal of a judge can only be justified where the shortcomings of the judge are so serious," and this is the critical section, "as to destroy confidence in the judge's ability properly to perform the judicial function." A fortiori, we say, if the public's confidence in Dr. Hlophe's ability to properly perform the judicial function has thus been destroyed, because we know he has been impeached, then the National Assembly failed to consider that as a relevant consideration. It failed to realize and to properly grapple with the fact that a disgraced judge and the public's confidence in him could never be redeemed by his appointment to the JSC. On the contrary, by that appointment, his disgrace would infect the JSC's work, and it would destroy public confidence in the work of the JSC. The second red light that was flashing brightly red, and which was ignored by the National Assembly, it failed to consider its own previous findings in relation to Judge Hlophe just a couple of months before. In July, it takes this decision, but in February, it took the decision to impeach. And when it did so, it had the Judicial Conduct Tribunal's findings before it, because it had a process which led to its resolution. And in the JCT's findings, and this is at case lines 02-140, it knew that the Judicial Conduct Tribunal had not just found that Judge Hlophe was guilty of gross misconduct, but of an egregious kind.
Was that the same National Assembly?
It was the National Assembly sitting in its purview of what impeachment was. And that National Assembly's conduct had already given rise, Justice Collins, to the impeachment decision. So the National Assembly, at the very least, had to have, even if it was in a different guise in July, it had to have proper regard to the fact that there had been a process of the National Assembly. And what had led the National Assembly to its decision in February? Well, one, the Judicial Conduct Tribunal's findings. Not small findings, very serious findings, including that there had been an attempt to influence Constitutional Court justices, including the finding that there had been a serious undermining of the Constitutional Court's integrity, and including that conduct had threatened confidence in the judicial system. Those were the bright red lights that were flashing, and the National Assembly was aware of that. The second thing that it was immediately aware of is that the National Assembly had confirmed those findings, justices, and it confirmed those findings in its own decision when it issued its media release. And you'll see that at 02-90. Its media release, when it adopted the reports by the Judicial Conduct Tribunal and by the Portfolio Committee is set out for you in a statement by the National Assembly, and it said the following. It said multiple things when it justified why it was going to impeach Justice Hlophe. But in particular, it said the JCT found that Judge President Hlophe's conduct threatened and interfered with the independence, impartiality, dignity, and effectiveness of the Constitutional Court, and that it threatened public confidence in the judicial system. So the National Assembly had done its own interrogation and had recognized that that conduct, that threat, had justifiably led to impeachment. And here then is the third and final red light that ignored. It comes from two judgments of the Constitutional Court, and I can end with these. The first, again, is Similane. In the Constitutional Court's decision, it explained that in an appointment context, the body doing the appointment, or the designating in our case, has to give proper reasons why it has chosen to ignore its own previous impeachment decision, and even if it was in a differently constituted way. The impeachment decision of the National Assembly has to explain it. Justices, Mr. Trengrove already made the point to you that there may have been multiple reasons, but if there was a particularly important feature, in this case, there was the important feature of impeachment, it needed to be properly dealt with and explained. And in the reasons, you'll see no discussion of this in the National Assembly. You'll see no reference of this in the 9 July letter of the Speaker. There's none of it. There is no grappling with that important relevant consideration. And by that light, then Similane is really the end of the case. Because have a listen to what the Constitutional Court said at paragraph 69 of Similane. It said this: on the face of it, the contradictions reflect on Mr. Similane's credibility, integrity, and conscientiousness. Here's the court. They were and remain material. Any decision by any person aware of this evidence, and here the National Assembly in our case had to be aware of this evidence, any decision by any person aware of this evidence to ignore it in a decision-making process involving Mr. Similane's credibility would have been, on the face of it, and in the absence of any explanation from that person, not rationally related to the purpose for which the power was conferred. There is no explanation in this case. None. There are after-the-fact efforts to try and explain. None of that is relevant, as I've said. But by the National Assembly's lights, there was no explanation for how it could overlook that obvious and glaring, brightly flashing red light. The second and final Constitutional Court decision, and I'm closing with this, it's relevant here. It puts paid to the defense that says that the National Assembly's ordinary practice or convention, it's the Justice Bakwa and Mr. Trengrove debate earlier, but wasn't this a precedent? Isn't this something that they've always done? Well, Mr. Trengrove highlighted for you, Justice Bakwa, that it may have been ordinarily done, but it was no excuse for acting lawfully in relation to a different committee, which was the appointment to a constitutional body in the form of the JSC. But in any event, the National Assembly couldn't rely on its own past precedent if this is a Padger case, which we say it is. Because you justices know you may not rigidly adhere to your past policies and thereby scupper or in some way render unlawful your discretion. So it wouldn't help for them to say, well, that was our past practice, that's just how we always did it. We're not permitted to do so. But there's a better and ultimately fatal answer to that defense through the Constitutional Court itself. And that is the decision of the Constitutional Court in Mazavuko versus Sesulu. It's referenced in our heads at paragraph 99.1.3 by our Freedom Under Law. It's case lines 13-35. This is what the court said. Because you're going to hear a lot about this with great respect, we're sure, from our learned friends about how it's important for national assemblies to be able to have political parties and minority parties debate points and ultimately try and do democratic work. Well, said the Constitutional Court, lobbying, bargaining, and negotiating amongst political parties represented in the Assembly must be a vital feature of advancing the business and mandate of Parliament. However, none of these facilitative processes may take place in a manner that unjustifiably stands in the way of or renders nugatory a constitutional prescript or entitlement. That is so because our Constitution is supreme, and demands that all law and conduct must be consistent with it. We may not hold that an entitlement that our Constitution grants is available only at the whim or the discretion of the majority or minority of members serving on the program committee or any other committee of the Senate. The Constitutional Court has had the word on this. It is said it's not sufficient. You may not rubber stamp. You must properly exercise the discretion. You may not allow a minority party in the form here of the MK to effectively dictate the outcome of your processes. And you cannot jettison what I've said to you are rationality standards, reasonableness standards, and a duty to consider relevant considerations, all through the lens of Constitutional Court authority. Those are our submissions from my side. Thank you, Justice.
Thank you, Mr. Du Plessis. We appreciate you being on time. You had 5 minutes left still.
Sorry, I just wanted to ask a question on the relief that you are seeking in the notice of motion. Paragraph 4.
Question on the relief.
Paragraph 4 of the notice of motion. You say that if you're successful, you would request the court to be furthermore put back to the National Assembly to get the decision referred to paragraph 2 to be afresh in accordance with the principles set out in this court's judgment. What are you envisaging the court should do?
Well, we submit that when a court upholds a review, it's the normal order that follows would be to refer it back to the decision maker to take the decision afresh. There are sometimes circumstances in which it's justified for a court to impose its own decision, but we don't contend that there are any reasons in this case for that extraordinary procedure. So all we have in mind is that we would make the standard order which sets aside the designation of Dr. Hlophe and refer the matter back to the National Assembly to fill that vacancy.
Yeah, but I think what my learned sister is saying is that in paragraph 4 of the notice of motion, we also proceed from the viewpoint that the matter must be referred back to the National Assembly, but also in accordance with the principles set out in the court's judgment. So I think that's what she is asking.
Oh yes, no. All we have in mind is that it is perfectly legitimate for you if you conclude that the National Assembly did not take the decision lawfully in the first place, in your judgment to give guidance to them about the manner in which that decision ought to be taken. And then in the order to say, I refer it back to you to retake the decision in accordance with the guidance provided to you in my judgment.
Yeah.
But that's entirely up to you. It's nice to have, but not essential.
Now, I asked it in the context of there are JSC sittings at least twice a year in this country.
Yeah.
So, obviously, there must be a time frame within which this has to happen. It can't be left open-ended. And then there's another JSC sitting coming up potentially in April next year, and then sitting with the same problem.
Absolutely.
That's what the court is working. Hence, I'm asking you, can you give input
Oh yes.
as to what the court should
Certainly, my lady, the new designation must be done in time for the next Judicial Service Commission. I'm not sure that date appears from the papers, but we will, I believe it's October, but we will certainly let you have that date, because the purpose would be defeated if the process, if there isn't a lawful designation in place in time for that meeting. You will have seen on the papers that there may even be doubts about the lawfulness of the constitution of the JSC if there is a member short. We don't want to get into that risk. So it would be important for the vacancy to be filled before the JSC convenes again.
Well, and if we're not prepared to consider and give a judgment on your application, bearing in mind the two other applicants merely asking for interim relief, what must we do then with the application? Instead of just dismissing it.
Well, no, with respect. If you find that the application is back, then you will dismiss it. But if you find that it is more appropriate to give interim relief now and consider final relief later, well, then you might postpone this application. It might even be tempting to postpone it to beyond the Constitutional Court's judgment in the pending matter before it. So those would be options open to you. But we submit with respect that we are here to persuade you that it is not necessary to go the A and B route, that there is a clear case for final relief. And if there is, then we submit with respect that the proper judicial response is to give that final order, not to prolong the process by interim and later final.
And your submission in this regard is you followed the Rule 6 route. There's nothing extra to be added to the whole recordings before the NA are there, and that's the whole record.
Yeah, no, entirely so. Interim relief is an appropriate remedy only if the matter can't now be finally determined. But if we persuade you, as we hope we do, that you can now finally determine the matter, well, then the need for the more cumbersome process of interim relief falls away.
Yes. On the back of my brother's question regarding what needs to be done, is the option that you referred to in the light of the Part A applications by the DA in the Corruption Watch, is that not, I know you're trying to persuade us, but maybe I'm trying to persuade you, is that not a better option in light of the Constitutional Court application that you've now joined or have applied to join by the Free AfriForum?
We would submit with respect. I understand the human inclination not to want to speak on an issue which the Constitutional Court is shortly to address. But that Constitutional Court judgment might take a very long time to be given. And we submit with respect that the priority, the proper priority, not the human temptation, but the proper priority of this court is to ask itself how best to solve the problem of an illegal designation. And we submit with respect, given the urgency that is common cause, and the problem that Justice Thomas had raised, the most appropriate and effective way to address the problem is to give a final judgment and have that vacancy filled. If you are later held to have been wrong, well, that's a risk that the judge runs every day. But your first duty is not to avoid being found wrong, but your first duty is to solve the legal problem which is presented. A national problem which must be solved in the national interest. Can you imagine if the appointment of judges were to be held up by a prolonged Misconduct process?
Well, I'd still try to get you around to the question of fairness. These applicants have come appropriately so on the Part A, and we've all gone through their papers as you have. And if they make out a case, is that not the fairer? As I say, it bothers me that there is this case at the Constitutional Court that must now come in and make a final determination, only possibly to be found to be wrong. Is that the way to proceed legally? Do you want to create such kind of precedents where we have now finally determined the court says no,
My Lord,
is that not the procedurally proper and thorough way of doing things in light of the specific circumstances of this case, looking at it, including there? I mean, I'm not excluding the possibility, nor am I prejudging that you have not made out a case.
No.
I'm just
I appreciate
considering
the question posed to that. I appreciate that. But let me say about that it is of course the burden of every judge. They might be found to have been wrong on appeal, but that is a burden that you bear with fortitude, and a burden that should not dictate the manner in which you perform your judicial function. And we submit with the greatest of respect that the proper performance of your judicial function in this case is to ask yourself how best to solve the problem before you. And we would submit with respect that if a case is made for final relief, then the proper judicial response is to grant that final relief. Interim relief does not make sense if a case for final relief is made before you. So that we would submit with respect that if you do find that a case has been made for final relief, that you are bound to grant final relief, because that is the proper judicial performance of the functions of justice. I understand the temptations otherwise, but I submit with respect that you do this.
Yes, and also finally on this issue, there seems to be a view, particularly as you are aware from the respondent side, who are saying we have come here and married on a case by these applicants, the other applicants, and to answer that, which we have done, and maybe that's the matter that we come to answer. The other is coming in, well, I don't want to say from the side, but that's not the one that has primarily brought us here. Isn't that a consideration the court also has to have if you can imagine a situation where you made out a case and they have also made out a case. I don't know if that's possible, but
with the greatest of respect, if they say they came here to answer a Part A case, well, they're just wrong. They came here to answer 3 cases. One of them is a Part A case and a Part B case, but another one is our application. Our application is for final relief. And I won't take the chance of asking you to ask them. I'm sure that a rational litigant who is here for interim relief would say to you that if my partner application, the other applicant, I don't want to call it partner application, we're not partners, not partners with it. But if the other application before the court today is one for final relief, and if you conclude that a case has been made for final relief, I'm sure that those people seeking interim relief would be the first to say to you, solve the case now by granting final relief, rather than the more careful route that we have contemplated.
Yes. Thank you for those responses, but we don't have the chances of saying what would you prefer.
No, I appreciate that.
We don't have that. So we've got to just look ahead.
Yeah, but you asked me what would the other parties say, and is it fair to the fellow applicants? My answer to you is that we brought our own case for final relief. It's a freestanding case, unconnected to any of the other cases. And if you were to find that final relief, a case for final relief has been made, then there really wouldn't be any good sense in not granting final relief.
Yes. I know, obviously, no brief to what's name, but ultimately, they're saying if you grant interim relief, and the relief that is being sought by FUL is similar to Part B, then we have a chance then to face that case and answer it maybe more properly, have more time to deal with it, And that's the order of things, and that's the manner these Part A and B applications proceed in anyway for review. That's how it happens, and then we'll have that. They will have obtained, if they do, the interim relief, and then there'll be no harm really in us then putting our case more properly there. Right now we're putting our case. That's my final question to you. Is that not the fairer route?
We submit with respect that if you conclude that a case, that Full has made a case of final relief, then it would be wrong as an incorrect exercise of your judicial function not to grant final relief, but to grant interim relief merely because other people have brought applications for interim relief. That fact should not determine how you decide this case. This case stands on its own and is entitled to be determined on its own. And if you find no case has been made, well, then it must be dismissed. But if you find that a case has been made, there is no reason for you not to grant a final order.
But if we do make the order, in the event of us making finding that interim order, you said the postponement to when would be an alternative?
No, it is not. Let me say, I merely accept that if you decline to grant final relief now for these tactical reasons that you've mentioned, then the answer would not be to dismiss the application for final. It would be to postpone it
to when?
To a future date to coincide with the Part B in the other application.
I see. Thank you.
Thank you.
Thank you, my lord. This time it is for noting. You'll be glad to hear. It's simply to say, I know I'm not the timekeeper, but they've gone over by 20 minutes. But apart from that, my lord, the point I really wanted to make is that Mr. Hlophe has now said that this is a separate application altogether, nothing to do with the other applications. Well, if that is the case, then, my lord, when are we going to deal with this separate case? Is it now, or is it part of the other case of the DA and CW? Because then the time allocations are completely skewed against us, if indeed we're here for two different cases.
Well, in terms of these cases which have different numbers, Mr. Hlophe,
yes,
which were set down today, and we are called on to adjudicate upon them, all three of them. This is what we are doing now. We have allocated time accordingly, and that's it. That's the way it's going to go. And we are having DA now to address us and people.
And the Part A case.
Yes.
Thank you. No, just wanted to understand that.
As the court pleases, Justices, it is now almost 12 o'clock. I don't know whether the court intends taking a company.
No. To solve the time issue, we're trying to adhere to that.
I've got no difficulty. Could I ask the court to indulge me then while myself and Mr. Cameron were to the front? We were accommodating Mr. Hlophe.
Yes.
If the court wants to adjourn for 5 minutes to visit,
they're going to do it quickly, please.
Justices, deal with, subject to not repeating arguments you've heard, briefly with jurisdiction, in as much as that's taken primarily by ATM. The grounds of review touch on the grounds of opposition and touch on the requirements for an interim interdict. And with regard to the latter, I'm going to focus on the reliance by our learned friends on outer, and will demonstrate to the court why that is not of assistance to them in this matter. Perhaps to begin, Justices, or before I do that, I should, especially in light of the debate that took up the court's time, or the debate that the court engaged in with Mr. Trent Gove at the conclusion of their submissions. We are going to ask if you are with us, that is in slightly different formats to our notice of motion, and that is only to accommodate. It doesn't change the substance at all. It is only to accommodate the now pending litigation in the constitutional courts, and our, as in the collective 3 applicants, conditional application to be admitted to the constitutional court. And that goes, we believe, with respect to what the court was raising with our learned friends.
Excuse me, Mr. Jamie, is that not the one that was loaded yesterday or the day before, the draft order on case line?
Has it been uploaded on case
There
lines?
was one, I can just check whether it's the same, but there was one loaded Monday evening.
I'm told by Mr. Bishop that it's the same one. I then apologise. I'm a Luddite, Justice, so I'd overlooked that. So apologies for distributing paper which
No, it looks a bit different, this one on case line.
This is a bit different.
But it also refers to the Constitutional Court case.
Some of my colleagues say it's the same, including Mr. Bishop, and then you say it's not the same.
Yeah, well, it's not. Must we work on the hard copy?
You must work on what I've just handed you, Justices, if you will. I apologise for any confusion in this regard.
Work on hard copy.
So the relief that we now move for, if you're with us, Justices, is that
We'll put up a proper notice or draft order after lunch, and I apologise for that difficulty. Before starting, perhaps I can just make one other submission that doesn't speak directly to our case, but may assist our learned friends and the debate which presumably they're going to engaged the court with, and which my learned friend Mr. Frengrave, as I understand, is going to reply to, and that is just this question of, and it perhaps also is apposite to mention it up front, because tangentially it may affect my clients. This submission that was made that it's unprecedented, bizarre, and in fact improper, and the court may not consider these three applications, which we have always understood to be absolutely separate applications. They've not been consolidated. They've all been heard together as a matter of convenience. But clearly asks for different relief to what we asked for and what Corruption Watch asks for. The submission that there's no precedent for a court hearing both an application for substantive relief and an application for interim relief in respect of the same underlying matter is not correct. It is not correct because in the so-called ZEP litigation in the North Gauteng High Court, where Justice Collis presided, Justice Collis would be well aware that their full bench of that division heard two matters, and I know this because I was involved in the first of them, which was a review of the Minister of Home Affairs' so-called ZEP decision in relation to Zimbabwean, the general exclusion of Zimbabweans from the limit system, bringing that to an end, the ZEP system, under which Zimbabweans live in this country. So there was an attack by inter alia Helen Suzman Foundation and another party, COMSA, on that, and they brought that in the form of review under a particular case number. A separate group of applicants, separate case number, brought an application in relation to the same decision, but in the form of a Part A and a Part B. And the full bench that was constituted to hear that matter heard the two cases sequentially. We argued the first case, I argued the first case for the Minister, the review, and the applicants argued, we responded, they replied, and immediately afterwards, the court, could have been the next day, but without interruption, the same court then proceeded to hear the interim interdict application in relation to the same decision, and on the 28th of June last year, the court granted two different judgments, full judgments and orders. I have the interim, the first case, the HSF judgment is reported electronically. I don't have the hard copy reference. I couldn't find it. I could just find the electronic version.
Where is the neutral citation?
I can certainly get, well, I do have it, I think, in my maths justice. In fact, I gave it to my little friend, Mr. Cohen. I'm sorry, I gave it to Mr. Massi. But I will give you the citation of both, and if the court wants, I'm in a position to give you, I've only got a single copy, but I have a copy of the judgment in the interim interdict application, and I just want to point out, and perhaps to make this orderly, I'll give the court copies of both judgments after lunch, if I may.
Yes, you may.
Because in the interim interdict judgment, it's instructed that the court did not grant the interim relief pending anything happening in the review case, where it gave judgment in favour of the applicants on the same day. It made an order that there was Part A relief in the interim interdict proceedings pending Part B of the same proceedings in this case. So the court dealt with them totally separately. And so to the extent that it suggests that there is no authority, of course, being on the losing end, I make no submissions as to whether that course was correct or not, whether the substantive judgments were correct. I'll reserve that in the interest of
Well, let's hope
comity, etc. But
let's hope you don't dig a trench for yourself.
I will attempt not to dig a trench for myself. So having said that, we make the simple submission. This, with the greatest respect, shouldn't entertain this court and delay the adjudication of the three matters. There is a precedent from a full bench of the North Gauteng High Court.
Yes.
Having said that, Justices, if I can then go on to the jurisdiction issue. As we understand it, it is taken primarily by ATM, and the objection is to, as we again understand it, to primarily to the adjudication by this court of the merits, the final determination of the relief that is being sought. So if we understand the objection correctly, it is the Fulls application and eventually, presumably, to our Part B application to be heard in this court. Because ATM certainly takes the point against us too. But we, with respect, submit that that is a fundamentally incorrect approach, because the question is not, insofar as we're concerned, it may be the issue insofar as Full is concerned, but insofar as we, the DA, is concerned, Justices, the question is not whether the Constitutional Court has exclusive jurisdiction. In fact, in order to consider whether you have jurisdiction to grant us interim relief, you must accept that the Constitutional Court does have final jurisdiction. Because it is only then that this question arises at all, whether the High Court may order interim relief pending a matter, the final determination of a matter which is not within its jurisdiction. If you are satisfied that you do have jurisdiction to make an order in respect of the merits, the final relief, then how far to your eye you have jurisdiction to order interim relief. It's only the reverse situation where you don't, or you think you may not, or you haven't reached the point of making a final determination as to jurisdiction, that you then need to consider, can you under those circumstances grant interim relief, notwithstanding that you may not potentially or definitively be able to grant final. Now, that scenario is not dealt with in cases like in Contemporaneous, which ATM says is the leading case on exclusive jurisdiction. It is, but not in relation to interim relief. The leading case on interim relief, Justices, is the National Gambling Board case of the Constitutional Court. And then following on that is the judgment in President of the Republic of South Africa versus UDM. And I could ask the court whether you have our bundle of authorities. I apologize, when I saw the bundle only last night, I realized that the type is very small. I apologize for that. It was too late to remedy that last night. If the court has difficulty, we can attempt to, or not attempt, we will furnish, oh no, I'm sorry, Justice.
Is that now the 960 pages?
It is the 960. I apologize for that too.
Papers, work with paperwork, and the paperwork until last night late.
I apologize. I'm sorry, Justice. But in the National Gambling Board case, the court makes this clear. You have the bundle. You have the National Gambling Board case, Justices. It starts at page. The judgment begins, Justice, at. It begins at 465, Justices, and I'm going to be referring to paras. Sorry. Yes. We reference it at para 48, Justices, where the court as a fact in that matter found that the matter was not within the Constitutional Court's exclusive jurisdiction, and hence it followed that the High Court had jurisdiction to deal with the interim interdict. So, strictly speaking, it's unnecessary for it to then deal with this question, but it proceeds to do so because it says it's important to give guidance, and then it proceeds to give the guidance. And the guidance is what follows 48, Justices. in para 49, the point is made that a court order preserving or restoring the status quo pending the final determination of the rights of the parties does not involve the final determination of these rights and does not affect their final determination. And the dispute in an application for an interim interdict is therefore not the same as that in the main application to which the interim interdict relates. In an application for interim interdict, the dispute is whether, applying the relevant legal requirements, the status quo should be preserved or restored pending the decision of the main dispute. And then it concludes that common law court's jurisdiction to entertain an application for an interim interdict depends on whether it has jurisdiction to preserve or restore the status quo. It does not depend on whether it has the jurisdiction to decide the main dispute. In para 50, it then goes further and explains how that approach is to be applied. It says in para 50, whether the High Court will have jurisdiction to grant interim relief pending a matter exclusively within this court's jurisdiction does not depend on the form or effect of the interim relief. It depends on the proper interpretation of the relevant provision and on the substance of the order. Do you have that, Justice Duffield?
Yes.
I'm sorry.
I've got it on
No.
the case lines as well.
As the book is. Does it? Does not depend and on the substance of the order. Does it involve final determination of the rights of the parties, or does it affect such final determination? And here is the relevant part. If it does not, the High Court will, depending on the provision that grants exclusive jurisdiction, have jurisdiction to grant interim relief. And then it adds the caveat, it does not follow the High Court will always have jurisdiction to grant or refuse interim relief, pending the decision of a matter exclusively within this court's jurisdiction. To decide whether the High Court has such jurisdiction, the provision in terms of which this court has exclusive jurisdiction must be interpreted. And then, if I could take the court down to para 52 and the last two sentences of that paragraph in 52, a court hearing an application for an interim interdict can obviously only decide the main dispute if it has jurisdiction to do so. A court that does not have jurisdiction in the main dispute will simply determine whether the applicant has a prima facie right to the relief which is to be sought in the court having jurisdiction to deal with it. And then in para 53, Justices, the last sentence, or the last two sentences, as a general statement of the position, there is no reason why the ordinary common law should not apply, provided that a High Court is not called upon to decide a dispute within this court's exclusive jurisdiction. It has jurisdiction to grant interim relief pending the final determination of such a dispute. Now, I must immediately point out that in para 54, the court expressly records that it's not deciding the question that arises in this case, because it says, in particular, we did not decide whether the High Court would have the power to grant interim relief to prevent an amendment to the Constitution from coming into operation, which is what this case was concerned about, section 1674D, or in circumstances where Parliament or the President has failed to fulfill a constitutional obligation, section 1674E. And that is what this case is concerned about. The court says these provisions confer very special powers upon this court, which may give rise to different constitutional considerations. There's no need to consider those questions now. So our submissions, Justice, is based on National Gambling Board, is that the court is stating a general approach which is applicable, but it expressly does not decide the question in relation to a 1674E issue, which is what we're dealing with. In the next case, Justices, is at the end of our bundle, and it may be a second version of the bundle, which has President of the Republic of South Africa versus UDM. I think it is one of a series of those cases.
See, it's at the end of this bundle.
We uploaded, it's page 953, Justice. We may have uploaded two versions of the bundle, but it's on page 953.
Yes.
As the booklet is. That case, in that matter, Justices, there had also been judgments of the High Court, one by a single judge and then confirmed by a full bench, in terms of which both of those courts had made orders suspending the coming into operation of certain constitutional amendments and related legislation. And that question came before the Constitutional Court as to whether those were properly made. And at para 23, the Court says, with reference to the National Gambling Board, it repeats what I've just, the submissions we've made. The fact of this Court, as the Court says, as was pointed out, or as was stated in National Gambling Board, the fact of this Court's exclusive jurisdiction was not in itself decisive in determining the jurisdiction of the High Court to grant interim relief. And this question must depend upon the proper interpretation of the relevant provision. So that was the applicant's or the appellant's argument, and the respondent submitted that in this case the High Court did not decide whether the legislation was unconstitutional, and thus there was no trespassing upon the powers of this Court, etc. And the Court in 25 says that these are important and difficult issues to resolve. As we read the judgment, Justices, and we particularly rely on what is said in para 25, having said that the issues are both important and difficult to resolve, the Court refers to the particular position of the legislature, that it has a very special role to play in a democracy, etc. And then further on in para 25 says the following: with due regard to that role and mandate, it is drastic and far-reaching for any court, directly or indirectly, to suspend the commencement. Now it's talking specifically about the commencement of operation of an Act of Parliament, which obviously goes to the heart of what Parliament does. And especially, so even in the very heartland of what Parliament does, or this is a reference to the heartland of what Parliament does, the Court says, it is drastic and far-reaching for any court, directly or indirectly, to suspend the commencement or operation of an Act of Parliament, and especially one amending the Constitution, which is the supreme law. Drastic and far-reaching. But then it goes on, and this is the part we rely on, Justices. On the other hand, the Constitution as the supreme law is binding on all branches of government, and no less on the legislature and the executive. The Constitution requires the courts to ensure that all branches of government act within the law. The three branches of government are indeed partners in upholding the supremacy of the Constitution and the rule of law. Now that is the passage we commend to the Court as providing the proper approach not only to jurisdiction, Justices, but to the substance of the challenge that we raise. Because even Parliament, when, as referenced in this passage, is acting within the very heartland of what the Constitution requires of it to make laws, including laws amending the Constitution, it is still not given a free pass. It must still comply with the constitutional obligations, which include, Justices, the obligation to act rationally, lawfully, and it is subject to ultimate control of the courts. No one in this country, we have no free pass, Justices, for any organ of state, from the President, from the highest to the lowest, includes Parliament. This is an unusual and difficult and hard case, potentially, but it still does not give anyone a carve-out from the ultimate control by the courts of their conduct and an assessment of their conduct. So we commend that passage to you in that context. as well as the context of jurisdiction. And then the court goes on in 26 to say, the answers to the questions must be found in terms of the Constitution itself. Then it does an analysis as to why, and it concludes at the end of that long paragraph by saying, on an analysis of the relevant provisions, section 79 and 121, it finds that on a proper reading of the Constitution, because having said that you must look at the Constitution, it says in a proper reading of the Constitution, no court may, save as provided in section 79 and 121, consider the constitutionality of a bill before the National Assembly or provincial legislature. If no court may decide the constitutionality of a bill, no court would grant interim relief. And those are the provisions, as the court knows, which require, or rather entitle, authorize the President or Premier, when a bill is placed before them, respectively a provincial or a national bill, if they consider that it may not be constitutional, they can refer it as a bill to the Constitutional Court for a ruling as to whether it's constitutional. It's called an abstract review because, in fact, it stands totally differently to the normal requirements of locus and rights being affected and so forth. And in that context, at the end of paragraph 27, the court says, in the case of an abstract review in terms of section 83, this court, and it alone, is empowered to suspend the operation of the impugned provisions pending determination of the challenge. And I emphasize the word the operation. Whether the High Court, and herein lies the point, whether the High Court nevertheless has jurisdiction to suspend the operation of an Act of Parliament, whether before or after they have been published, is a question which it is not necessary to decide in this case. In what follows, we shall assume that there might be exceptional cases in which the High Court might grant such an order. So in other words, even in the context of section 83, where the High Court, where only the Constitutional Court may suspend the operation of the impugned provisions, the Constitutional Court assumes that there might be exceptional cases in which the High Court could make an order relating to an Act of Parliament. And then in 28, it explains its reasoning, Justices, by making the following point, and this is relevant to the merits of our case, as also the argument that we have not sought an interdict against Parliament, but only
case. Even under those circumstances where exclusive jurisdiction vests in the Constitutional Court, the Court is saying, while the High Court may have no jurisdiction to suspend the operation of the legislation coming into effect, it can still grant an order in relation to interdicting actions and the consequences of actions that are taken pursuant to the impugned legislation. In other words, it draws a distinction, a common sense, practical distinction. This court, the High Court, may not have jurisdiction to either make an order finally, because the Constitutional Court has exclusive jurisdiction, and also because of the separation of powers and the important role of Parliament, not even have the power to make an order suspending the coming into operation of the legislation. But even under those circumstances, it would still potentially have the power to make an order that interdicts or affects actions taken pursuant to the impugned legislation.
Mr. Jamie, you have now taken a lot of time to deal with that judgment, but is the conclusion of the court not in paragraph 32?
I have taken some time, and in paragraph 32 the court...
the crux of the matter? Where in that paragraph?
It is indeed justice, the view. And we submit that in line with the National Gambling Board case and this judgment, this court definitely, we submit, has the power and the jurisdiction to grant interim relief, as we seek. If I can then, Justices, go on to the grounds of review. And as I've said, I don't intend repeating the arguments that have been made. We've set out the grounds of review, and unlike FUL, we have three grounds of review, Justices. The first is that the designation by the National Assembly of Dr. Hlophe was substantively irrational. The second is that it offended, it did not advance, as it was required to do, the obligation on Parliament to comply with Section 1654 of the Constitution. Instead, it undermined and was retrogressive in respect of Section 1654. And the third is the ground, which is also common to FUL's application, that there was an error of law in this matter. And that error of law, we submit, arises from, as you heard argument, we adopt the same position, arose from the misapprehension on the part, certainly of the majority party, the ANC, that they had no choice but to comply with a practice and or to act in the situation where, according to them, there was a lacuna in the rules or the Constitution. And that those assertions by them form part of the record. On irrationality, Justices, it's a trite proposition. We deal with the authority at footnote 17 of our heads. I'm not going to take you there. That for a decision to be rational, there must be a rational connection between means and ends. That's, in essence, the requirement. And in looking at means, the court looks both, and the court can also consider the process arriving at the election of the means to achieve the end. Now, in that context, we have made submissions about the purpose of the designation by the National Assembly of its component of the members of the JSC. And we agree with our learned friends for FUL that that purpose is to foster respect for the judiciary and to reinforce the moral authority of the judiciary. I just want to emphasize one aspect, and that is the judgment. It's in our bundle of authorities, State versus Mamabolo. I'll give the court the reference right now.
Well, it's on the footnote 16. It is 2001 3SA 409 CC.
That is so. I'm not going to take you to footnote 16, Justice, but if I could take you, I don't have to take it there, I'll just read it to you. At para 19 of that judgment, after describing the way courts function, the court says the following, and this is a passage that we submit as of application in considering this matter. In the final analysis, it is the people who have to believe in the integrity of their judges. Without such trust, the judiciary cannot function properly, and where the judiciary cannot function properly, the rule of law must die. Now, that is relevant because, with respect, and this would be apparent, we submit, to a person totally unschooled in law. If they consider the object, and we in our heads say there are only three relevant facts really in this matter: the removal of Dr. Hlophe for gross misconduct, his designation by the National Assembly to serve in the JSC, and the fact, well, really they're just those two facts. Their juxtaposition in time, that they were so close to each other, is not an elemental fact, but it is also a fact. We add one further caveat on that first fact, that he was removed, Dr. Hlophe was removed for gross misconduct by the National Assembly in terms of the Constitution, that notionally it might be possible to, if one could do that, to differentiate between degrees of gross misconduct and how those feed into unsuitability to be on the JSC. So it's at least conceptually possible, you could say, the judge was removed for gross misconduct, but that doesn't obviously disqualify him from being on the JSC and selecting judges. And accepting that notionally, we submit it's not relevant for you to determine that for two reasons. The one is that it's sufficient, and our pleaded case is that removing or putting onto the JSC, the body that selects judges, putting on that body an individual who has been removed and found to be unable to not comply with the requirements of the Constitution and the law to be a judge is on its face irredeemably irrational. It would make no sense to anyone who looks at the process and says, well, if you're not able to be one of the people that are being selected, how on earth can you be in a position to select those people? And that, the law very often it resolves itself in the absence of express authority to common sense. Here there is no express authority or precedent for the situation that we face in this case, precisely because it's unprecedented. But the fact that it's unprecedented factually doesn't, with respect, justices, mean that it's untethered from legal principle and in particular common sense. And the legal principle, we've said on our heads, our learned friends have made the same points, we've referred to the authority, but the common sense position is the one I've just put to you. How can someone, and this just offends, it offends on the most basic of levels, and accepting rationality is a low standard. How can someone who's not fit to exercise an office be fit to appoint people to such office? And in fact, further, not only not fit to occupy the office, but was in occupation of the office and was removed for being unfit. And then the second submission I want to make in that regard is the peculiar nature of the misconduct. And it's on the papers, I'm not going to, it's in DA 1 is the transcript of the Judicial Conduct Tribunal proceedings. And from reading that, DA 1, you have the references in our heads, justices, you will see. And in fact, if I may be permitted, I don't want to unnecessarily take up the court's time, but can I just refer you to what Dr. Hlophe was actually found guilty of? This will be found on the final page at 174 of the record in volume 1. I don't know whether your volumes are divided into numbers, but it's case lines 174.
174.
174. Sorry, 1/74. Volume 1, 74. The other justices. This was the conclusion of the Judicial Conduct Tribunal, which, as we know, was accepted by the JSC. Judge President Hlophe's conduct breached the provisions of Section 165 of the Constitution in that he improperly attempted to influence two justices of the Constitutional Court to violate their oaths of office. That is what he was found guilty of. And that led to the conclusion in 124 of gross misconduct. Now, it is difficult, with the greatest respect, Justices, to conceive a more fundamental dereliction and violation of your oath, your judicial oath, where you are found guilty of attempting improperly to influence two other judges to violate their oaths of office. You could not be more untethered from the requirements of a judge and be more unfit to choose other judges. Anyone, and I make the submission at that level of generality, anyone faced with the bare bones facts that someone found guilty of that has now been put by Parliament into the position of selecting other judges would say, how can that be? That makes no sense. That's what the ordinary person in the street, we submit, it's a submission. I'm not leading evidence before you, will say that. How can that be? And that is the standard of irrationality. There is no connection. It doesn't further any of the purposes behind having a carefully calibrated, constitutionally ordained JSC with all those different constituencies having to sit in the JSC that brings the various interest groups, etc., their interests into play when judges are selected. But it's all designed to end with a rational purpose, which is to uphold the integrity and the moral authority of the judiciary, without which judges and courts can't function as the authorities that we cite in our heads say. And in that from that viewpoint, it was fundamentally irrational. That's our first ground.
Well, that will have to be considered objectively.
Yes.
Because you're referring to the man in the street, but what we know here is that the MK party obtained 15.4% of the voters, and they were that party nominated their MP, Dr. Hlophe. So from their point of view, there was nothing irrational about that.
From the MK viewpoint or their voters?
Well, the MK that were people that were voted into Parliament.
Oh, I see. Yes, no. We know that, but that of course can't be. I'm talking about the standard justice defer, not the. Sorry, rationality is an objective.
That's the point that I want to make. It's an objective.
It's an objective criterion it must be, and my submission to you is that objectively. So it's quite apart from what MK thought, because we accept that MPs may vote. MK certainly may vote. It was their nominee, as they see fit. But the question is that, and we made the submission, no action. So it's not an answer, with the greatest respect, to say, well, it was a political decision. It's different if it was a pure political matter which had no constitutional implications, ramifications. Here, and of course you're aware that the designation power was not given to any particular party. It's given to the National Assembly. Could I just, I believe, I didn't check.
Oh, he's got 20 minutes plus another 10 or so. Half an hour.
Just before 12.
That's good.
It seems if I'm going to be kept to my time, I have to finish at 1.
Yes.
Then I'm going to I'm going to short circuit what I was going to be saying. So we've made the irrationality ground, Justices. We've made the Section 165 ground, and we've set it out. I don't have the time, well, I'm not going to add anything to that. We've made the error of law ground. I've referred you to the underlying facts there. You may just want to, if I could give you certain references, Justice. 514 and 532 of the, sorry, those are the Speaker's affidavit regarding what occurred factually, and it's paras 35 at 514 and para 58 at 532, and we ask the court to have regard to that. I just want to. Could I just ask one thing? If I could just refer the court very briefly to what the Speaker says in her affidavit at para 58. Justices. And I do just want to make brief submissions on this. At para 58 of her affidavit, the Speaker, and it's to be found at 5/32, where the Speaker says in para 58.1, as a general proposition, courts are not concerned with the motives of members of the National Assembly who vote in favour or against a particular motion or legislation. We agree that as a general proposition that is the case, but here of course we know why at least the ANC voted as they did. I'm not going to take you to that again, but the passages in the record which my learned friend Mr. Trengove took you to earlier make it very clear that the ANC thought they had no option, that they had to vote because there was either a lacuna in, as they put it, the rules or the Constitution, capital C Constitution, or they said, well, there's this practice and we can't go against the practice. So, and thus we agree that they didn't exercise a proper discretion, but the point is we know why they did, why they voted as they did. In 58.2, it must be accepted that the nomination of Dr. Hlophe by the MK party is purely a political decision of that party. We agree. That's outside the remit of this court to interrogate. But then, importantly, however, it does not necessarily follow that a choice of a political party must be rubber-stamped, i.e. rubber-stamped by the National Assembly. And we totally agree with that. And that is a fundamental statement which is not disputed by anyone in this matter, including the respondents. The National Assembly was not bound by the nomination of the MK party. And what we say, Justices, is even if there was a parliamentary practice in terms of which, in matters of this sort, well, firstly, the parliamentary practice, which when you read the Speaker's affidavit, and if you read the record in this matter, and especially it is DA1, it is quite clear from that the practice that they are talking about is a practice that related, as my learned friend Mr. Trengove submitted, to the appointment of parliamentary subcommittees, portfolio committees. And they said invariably parties have a right to nominate who they want to be on these committees. That may well be a question of parliamentary process. But we agree with the submission that this is not a parliamentary committee, the JSC, obviously. It's a constitutional body standing outside Parliament, to which Parliament, National Assembly, is required to designate members. It cannot be bound by their own legal or their own practices. But even, so that's our first submission, and that in fact there was no binding practice in that regard. But even if there was, Justices, if there was such a practice, it clearly cannot once again stand outside the scrutiny of the courts. And if that practice led to an irrational result, as we say it did, for all the reasons that we and the other applicants say it did, then that is the end of the matter. It wouldn't withstand scrutiny. And then the last statement of the Speaker, 58.3, is that the majority decision of the National Assembly on 9 July as to the designation of Dr. Hlophe is also at the very least a political decision and an expression of duly elected representatives in terms of the electoral system, etc. And while that might be so as a general proposition, Justices, here, on the facts, you know that the majority party, being the ANC, I repeat, thought they had no choice. And that's why they voted the way they did. Had they known that they had a choice, had they appreciated that they had a choice, on the numbers, we've averred in our papers that the ANC has 159 members. The court can take judicial notice of the fact that the DA has 87. The most elementary, well, it's a fact of which the court can take judicial notice. The most elementary Google, as I did last night, shows the numbers in Parliament. There are 400 members in terms of Section 77, I think, of the Constitution. And the ANC is 159 and the DA is 87, plus the 9 that are shared between Freedom Front Plus and ACDP, both have voted against Dr. Hlophe, would comfortably be majority votes. So in other words, the error of law here made a difference. To the extent that there's a that the ANC is not the National Assembly, fair enough, we accept that. But the error under which the ANC acted when it took the decision here, when it decided to vote, made a difference. So those are those submissions. With regard to submissions on the merits, with regard to the grounds of opposition, we will respond. We've set them out in detail in our heads. I'll respond to anything which is particularly raised, which we haven't covered in response. With regard to outer, I think Dr. Hlophe especially, both Dr. Hlophe and MK, criticize us for not pleading outer. Well, outer is law, Justice. We don't need to plead the law. But the long and the short of it is, to the extent that they contend in respect of outer that we are not the court is not entitled to look to our prospects of success in order to establish a prima facie right, that is simply wrong. We've given you the authorities in our heads. It is SA Informal Traders and Vaal River. And the footnotes are respectively 82 and 83. And there the court, especially in Vaal River, found unequivocally that strong prospects, I think it was Justice Madlanga and that strong prospects of success in the ultimate review proceedings could establish a prima facie right. However, our learned friends are also fundamentally wrong, and they share that error with lots of people, government respondents, who attempt to use outer as a shield against scrutiny by our courts. And they jump up and down and they trot out like a formula, like a magic spell, which is going to keep the wicked witch away from them. They talk about clearest of cases and exceptional circumstances, the outer formulation. But what they miss, and what our learned friends, the respondents miss in this case, Justices, is the distinction between an outer has application, that formula, or that formula about clearest of case, exceptional, etc., applies where a party is attempting to interdict the exercise of public power, attempting to prevent a public body from exercising its power. And the more policy-laden and polycentric that power, the less keen a court would be to do that, to intervene and prevent a public body, especially a body like Parliament, from exercising its power. But here, those are not the facts. Parliament has exercised its power. It designated Dr. Hlophe. And that is done and dusted. Parliament is not going to do anything further in the matter. And hence I referred to the distinction and went to some length, and I apologize for that, Justice Defoe, to some length in the UDM case to demonstrate that there's a distinction between the power and or the initial power and conduct flowing therefrom. Here, what we seek to interdict is Dr. Hlophe acting in terms of the designation by the NA. But we can't interdict the NA because there's nothing to interdict. The NA has acted. It's not going to act any further. What we are seeking to interdict is Dr. Hlophe. We do target, or not target, that's the wrong word, we name Dr. Hlophe in our Part A, whereas in Part B we name the NA. But that is understandable and entirely logical because of the facts. It is Dr. Hlophe who, in going to the JSC, in pursuant to what the NA has done in the past, which we can no longer interdict, it is that that gives rise to the harm, not the NA's designation per se. Had Dr. Hlophe in his wisdom said, I see what you've bestowed on me as the National Assembly, but I feel I cannot take it up for all the reasons that we've raised, then of course there would be no harm. But he has taken it up, and that is what causes harm, and that's why we want to interdict that, which addresses one of the major issues raised by Dr. Hlophe, but more importantly, on the question of the stage at which you seek an interdict, the authority pursuant to ARTA is EFF v. Gordon, 2020, Volume 6, SA 325, Constitutional Court at Para 60, where the Constitutional Court makes it clear that the ARTA standard, the formula that I've referred to, only does not apply where the exercise of power has already occurred and only its implementation is being interdicted, sought to be interdicted. And that is the case here.
Can you just give me that citation?
EFF, Justice Defoe versus Gordon.
Oh, yeah, the Gordon case.
20, do you have it? 2020. So we say ARTA is of no assistance there. Can I just check something? Yes, I've been asked to see what we say about balance of convenience, justices. We've made our submissions on balance of convenience, and to the extent that that is something that Dr. Hlophe especially relies on, we submit that the balance of convenience, and of course we're dealing now with an interim interdict, which is what our relief seeks, and the bar is significantly less than for final relief, and we again quote that authority in our heads. But one of the aspects the court will consider is balance of convenience. Now, the balance of convenience we submit clearly favors the applicant, the Democratic Alliance. If you're with us on prospects, which we submit you should be, justices, then if an interdict is granted in the format that the draft order postulates, it will be pending the determination by this court or the Constitutional Court of the merits. And we don't know how long that may take. It certainly will, we would imagine, prevent Dr. Hlophe from attending the imminent October sittings of the JSC. I think there was some suggestion in the court of sittings in April next year or sometime next year. I don't know when those sittings would take place. I don't know. I can't make submissions as to whether these matters will be resolved by then, by the next sitting. I don't know when that would be. But it would involve practically Dr. Hlophe missing certainly the October sittings and perhaps another sitting. And that would be the harm, the inconvenience, if we ultimately lose, but we get an interdict now. That pales into insignificance compared to the harm that we, both in our own capacity, but also as representative of our voters, and perhaps, sorry, that's something I didn't emphasize enough, to the extent that MK makes a very big deal of its rights representing its voters, we are entitled to make the same claim and rely on the same, make the same assertion in respect of our voters. Our voters expect us to assert principles of transparency, accountability, judicial integrity, etc. So we clearly, to the extent that there's some suggestion that we may not have locus, we submit with respect that is a risible suggestion. We clearly have locus, both to act in our own interests and in the interests of the voters we represent and in the broader public interest. So, to get back to the issue, Justices, of balance of convenience, as compared to the inconvenience of Dr. Hlophe, the inconvenience that we would suffer if we do not get an interdict but are ultimately successful in the review, in whichever court, is that Dr. Hlophe would have sat in matters where his presence and participation fundamentally taints the selection process in those sessions, where there's always going to be, without any, through no fault of their own, those judges who have been appointed by JSC, including Dr. Hlophe, will, with respect, forever go through office or occupy their offices with a bit of a question mark as to, well, was this entirely above board? Were you, given that we don't know what happens, we know the JSC must now disclose their deliberations, etc., a record of deliberations, but you still don't know what happens in a closed body like that. Who influences whom, what conversations are held off the record, etc. That question mark remains. It affects the independence and the regard in which the judiciary should be held. There is no reason to impose that burden, and that burden on the judges concerned, but also on the justice system. So we submit there is no common comparison. To the extent that, it's just one thing I do want to emphasize, we make the submission in paragraph 53.4, to the extent that anyone, the respondents, want to rely on separation of powers harm, I've already made the submission, there is none. But as we say in that paragraph, that cuts both ways. Because if there's a separation of powers issue, given that this concerns the composition of the judiciary, which is one of the pillars, the three constituents of the separation of powers, and maintaining its integrity, arguably separation of powers demands court intervention to protect the integrity of the justice system and the judiciary, which is one of the three arms of government. So far from pointing away from relief, it supports relief. Sorry. And then those are submissions on merits, justices. We submit that the DA, the Democratic Alliance, is entitled to the relief it seeks. We submit that relief is appropriate in the circumstances. We elected not to seek final relief at this point, and we did so for the reasons that I think we've articulated in our heads. We thought it more appropriate to ask for interim relief, so as to get the benefit of the full record, to allow the parties to make their averments on full papers, and most importantly, perhaps, to give the court the opportunity to give proper consideration to its determination of this very important, unprecedented matter. And we make no apology for following that route. It's not that we thought our case wasn't good enough or strong enough to give us final relief. We did that, or followed that course as a judgment call by the lawyers. That being said, Justice, we deal with the various scenarios at the end of our heads of argument, depending on which way the court is inclined to go.
Obviously,
those are our submissions.
The flip side of that submission is that would be the fairer route as opposed to what is submitted by FUL.
I wouldn't want to rain on FPR's parade, Justice. Mr. Kuhn gave us a fearsome. I'm not saying it would be fairer. I'm saying, in my case, which is
yes.
the only case I have to advance, we submit it's entirely appropriate, really.
That is an answer, Mr. Jamie, will I say.
Close the door, please. Unless there's anything else, just. And then costs. I'm terribly sorry. Costs. Justices, if you're with us, then we submit the application. Our application should be granted with costs. And in that regard, I must submit to you that, in particular, given the egregious nature of the allegations made on the part of the respondents, but primarily on the part of MK, and which allegations or slurs and scurrilous attacks on the applicants, including my client, are made in the heads of arguments, and particularly paragraphs 4 and 5 of MK's heads of arguments, where there's an entirely vile reference in our submission to the abominable murders which occurred in a farm in Limpopo, where the victims were allegedly fed to pigs. The attempt to make some connection between our clients and their motives in that case is entirely unacceptable. It is conduct that should not be tolerated by any court. To the extent that the respondents complain of abuse of process, that is an abuse. And we submit the court should signify its distinct displeasure, in particular with the way MK has conducted this litigation by granting a punitive order against them.
Against MK only.
It's against MK, the fourth and the first respondent. The first, or you seeking? You
Yes.
say first and the fourth.
These are the first and the fourth. Yes, I'm told that is so. My instructions are to move for such an order against first and fourth. My instructions are to move such an order against first and fourth. I'll leave it in the court's discretion as to whether the first respondent has so conducted itself as to warrant such an order. But my firm submission is that fourth has. Unless there's anything else, Justices, those are our submissions.
Thank you, Mr.
Mr.
Jamie.
Court.
Appreciate it. Thank you for keeping time. So, according to our plan, it's agenda 32. Yeah. Agenda 32.
Yeah.
Will they be gone in an hour?
that recommends judges for appointment. That means that someone who was impeached and dismissed by Parliament because of gross misconduct committed as a judge will now be interviewing and determining who should be judges in this and other courts of South Africa. Now, this is an obvious and extraordinary conflict of interests that should never have arisen. When someone has been impeached as a judge and removed, suddenly they appear at the top of a list of a political party and become MPs. That underscores the suspicion and the distrust that many South Africans have of politicians. Someone who wasn't thought fit and proper to be a judge then appears as a very prominent MP for the MK party and then duly gets nominated to interview and select other people to the judiciary. Now, it would be a travesty if the DA sat back and allowed that situation to develop. Our constitutional democracy is built on the independence of the judiciary. It depends on judges who are above reproach and who act in a way that protects the Constitution and the law without fear or favor. And it is relevant in this context that Dr. Hlophe, the former judge president of the Western Cape, was impeached after a 16-year battle started by myself as Premier of the Western Cape back in the day. Started by us because he attempted, against his oath of office, to influence judges of the Constitutional Court to rule in favor of Jacob Zuma. Now, a more egregious and extreme case of judicial misconduct would be hard to find. And so, while we respect the fact that MK, in terms of the law, has a right to nominate someone to sit on the Judicial Service Commission that chooses judges, we contest the fact that they may choose someone who has such a profound conflict of interests. MK has argued that we cannot quibble or second-guess their choice for the Judicial Service Commission. And they say that Parliament has designated him, in fact, to serve on the Judicial Service Commission. The critical, pioneering, precedent-setting issue before this court is whether someone who is so entirely compromised and was seen as unfit and improper to serve as a judge should be allowed to be in a position where they interview and select judges. We believe that this is a watershed case for South Africa, and it will go down in history as the case that either defended the independence of the judiciary or compromised it. We hear with other interested actors, Freedom Under Law, for example, and CASAC, the body that defends the South African Constitution, and we are here together because this issue affects every single South African. This is a matter that will touch anyone who ever has a family member who ever appears before a court of law. If you want an impartial judicial hearing that is free and fair of political influence and where you can trust that judges only uphold the rule of law and the Constitution, this matter affects you. And the DA is acting on behalf of every South African, whether they support us or not. Thank you.
And Section 165, all of the grounds of review have been canvassed. But our submission is this: for our purposes in our case, we have strong prospects of success in Part B of our case. That's my first topic. My second topic is the composition of the JSC. There's an argument made that if interim relief is granted, the Judicial Service Commission will not be properly constituted. And we say that that's a bad submission. In our heads of argument, we quote a case between Dr. Hlophe and the Judicial Service Commission. I'd like to take the court there briefly. It's on page 1431 of the heads of the bundle.
Repeat the page.
1431.
Paragraph?
That's paragraph 82 of our heads. And we cite the case Hlophe versus Judicial Service Commission. In that matter, point was taken that because certain members of the JSC were not present due to conflicts, the JSC was not properly constituted when it made a decision pertaining to Dr. Hlophe. And the full court in Gauteng rejected this argument. And I can just go to paragraph 39. They deal with a lot of case law, including JSC versus Cape Bar Council, the Nuclex judgment from Justice Chaskelson. In paragraph 39 there says that what emerges then from these cases is the inference that proceedings will not be regarded as a nullity if there are justifiable reasons for an absence or exclusion of a member entitled to sit. If this court grants an interim interdict, that is a justifiable reason for Dr. Hlophe not to sit.
Does the JSC have a specific quorum?
Well, look, that's the answer on that the case dealt with it. If someone can't sit for a justifiable reason, then the proceedings are not a nullity.
Yes, no, I'm asking in the sense of a minimum number of people who must be present.
Well, it depends on what they're doing. We know in some of the other cases, like the Premier of the Western Cape case, I don't have the citation, but in that matter, Premier at the time of the Western Cape challenged a decision that was taken in her absence. And she said she was a necessary party, or necessary part of the composition of the JSC.
Yes, I recall.
And the court upheld that. And this argument was made in this case that, well, without certain members of the JSC who were conflicted sitting, I think it was the Chief Justice, perhaps even the Deputy Chief Justice, they couldn't be properly constituted. They weren't properly quorate. The response of the court was, well, if there's a justifiable reason for their absence, then the proceedings of the body are not a nullity. But my lord, that's only my first proposition. My second proposition is this, is that we've targeted our relief against Dr. Hlophe very deliberately. And much is made of this. Much is made of this in the answering affidavits about not suspending the effect of the decision. But we identified Dr. Hlophe because what we thought was, if he is interdicted, the National Assembly can designate someone else in the interim, if they need to.
Yes.
So there's no question that the JSC will be properly constituted if this court were to grant interim relief, as our client asks.
Yes.
Well, those are my submissions. Now, Ms. Marriage-Pillay will continue.
Thank you, Counsel. Yes, Ms. Marriage-Pillay.
I intend to deal with three issues. First, the issue of harm. Second, and allied to the issue of harm is the balance of convenience. And finally, deal with the issue of standing that has been raised as an eliminate point by the MK party.
Yes.
In relation to harm, we submit Corruption Watch has demonstrated the harm that will be suffered is irremediable and irreversible in character. This is an interim interdict that's being sought pending the outcome of a review. And this would mean that a favorable outcome by the court reviewing what we claim to be objectionable conduct cannot be made in order, cannot then make an order that would effectively undo the harm that we allege in Corruption Watch as found in papers. Dr. Hlophe's participation in any judicial selection process will severely undermine the dignity of the JSC and the public confidence in its assessment of whether judicial candidates meet the fit and proper requirement prescribed by the Constitution. We submit that permitting him to participate in the judicial appointment process as a member of the JSC, particularly in the upcoming October 2024 interviews, would then compel other members of the JSC and judicial candidates to spend considerable time convening and participating in proceedings which may lack legality if the decision to designate him to the JSC is ultimately set aside on review in our Part B. The response to this from Dr. Hlophe and the MK Party is that this harm is entirely speculative. Dr. Hlophe asks on what facts or evidence is it alleged that he cannot be trusted to conduct himself in accordance with the oath of his office. And he claims to be incorruptible. The MK Party suggests that our fears should be allayed by the fact that Dr. Hlophe is bound by the oath of office he is taken as a member of the National Assembly. And our submission is this. This does not ameliorate, but rather aggravate the well-grounded apprehension we have of harm. The current oath Dr. Hlophe has taken as a member of the National Assembly is set out in Item 4 of Schedule 2 of the Constitution, and that includes obeying, respecting, and upholding the Constitution. This isn't different from the oath that he took as a judicial officer, as also set out in Schedule 2. He was found to have breached Section 165 of the Constitution in that he improperly attempted to influence two justices of the Constitutional Court to violate their oaths of office. His conduct was found to have seriously threatened and interfered with the independence, impartiality, dignity, and the effectiveness of the Constitutional Court. His conduct was found to have threatened public confidence in the judicial system. And what we see today is that he remains unrepentant for such conduct. He persists in criticizing the JSC and its processes. Justices, you can see that at page 1020 and paragraph 68, page 0482 at paragraphs 188 and 189, and in the written submissions filed on behalf of Dr. Hlophe at page 1547, paragraph 98, Dr. Hlophe alleges that his removal from judicial office was unconstitutional, was not just legally flawed, he says, but characterized by incompetence and deliberate political interference. The harm that we have and Corruption Watch has is real and well apprehended in the circumstances. The relief we seek in Part A is not final. It does not dispose of any of the issues or any portions of the main dispute that's set out in Part B, and it doesn't anticipate or preclude some of the relief which would or might have give rise at the review proceedings. The suggestion by Dr. Hlophe that the interim relief we seek is final in nature is just unsustainable. At most, Dr. Hlophe will suffer an inconvenience or the disadvantage of missing, at this stage, one JSC sitting. This pales in comparison to the harm that I've already demonstrated. In relation to the balance of convenience, we've set out already the issues on the prima facie right and the harm. And I need to say nothing more than the high watermark of Dr. Hlophe and the MK Party's contentions about harm is that should the interim relief be granted, the JSC will be improperly constituted in his absence. Mr. De Beer has dealt with that. There is no harm alleged by the JSC or the National Assembly. There is no concern raised by them regarding the composition of the JSC, nor has the National Assembly suggested this is going to be an unwarranted intrusion into its functions.
They haven't opposed the application, so they can't not to abide.
Correct.
Yeah. So there's no evidence to say that this is the harm that they'll actually suffer.
No, there isn't. So for those reasons that we submit, this is one of the clearest cases where interim relief is appropriate. The final issue I want to deal with is the issue of standing, which has been raised as an in limine point. With respect, the challenge to Corruption Watch's standing is a non-starter. Given the standings asserted by Corruption Watch based on both Section 38 of the Constitution, and more broadly because if this is constitutional litigation asserting the principle of legality, the conception of constitutional standing is far broader than our understanding of common law standing. Corruption Watch did not have to show the same sufficient personal and direct interests under the as it would have had to do under the common law, but rather that the impugned decision affects its rights or potential rights and interests. Dr. Hlophe and the MK Party gloss over this. Dr. Hlophe does no more than present a bold denial of standing in his answering affidavit at page 04105, paragraph 296. He does not appear to persist with this in his heads of argument. The MK Party does not make an effective denial of the assertion of standing by Corruption Watch, other than to contend that none of Corruption Watch's objectives or activities have any relationship with the present dispute. That's not factually correct in the papers before the court. The complaint giving rise to Dr. Hlophe's impeachment was an allegation that he improperly attempted to influence constitutional court judges pending judgment in the Zuma Tint matter in favor of Mr. Zuma. You will see that summary in the tribunal's decision at page 0358, paragraph 7. The tribunal heard evidence that Dr. Hlophe had a discussion with Justice Mxibinda by bragging about his political connections, followed by a subtle threat that people were going to lose their jobs once Mr. Zuma ascends to the presidency. You will find that at 0395, paragraph 109. The tribunal found that this points to an attempt to influence. And there was a finding that he improperly attempted to influence justices of the Constitutional Court to violate their oaths. Within months of his impeachment, he's taken up position as an MP and nominated to the JC, but not just any political party. It is a party whose founder is the very person who stood to benefit from the influence that Dr. Hlophe sought to exert on the constitutional justices. These issues plainly implicate Corruption Watch's pleaded mandate promoting transparency, integrity, and accountability in the functions and operations in both the public and private spheres, of holding office bearers accountable, and for analyzing the erosion of good governance. We set that out clearly in our founding affidavit at page 0313, paragraphs 13 and 14. Further, one of Corruption Watch's stated objectives in its Memorandum of Incorporation is to engage in impact litigation, which includes administrative reviews, such as that set out in Part B of our application. And you will see that in the MLI that's attached to the founding affidavit at page 0340, clause 2.2.6. Corruption Watch's objectives and activities plainly have a relationship with the present dispute. It's not solely acting as an own interest litigant, it has also brought this application in the public interest in terms of Section 38D of the Constitution. And insofar as there's a denial by the MK Party that Corruption Watch is acting in the public interest, it merely states that Corruption Watch hasn't explained why the public have assigned that interest to it. But respectfully, that misconstrues the test of standing constitutional litigation. Section 38 of our Constitution introduces what the Constitutional Court says is a radical departure of the common law in relation to standing. It explicitly provides that where it is alleged that a right in the Bill of Rights has been infringed or threatened, anyone acting in the public interest may approach a court for relief. As I've stated at the beginning, Corruption Watch...
Sorry, can I just ask you, so which right are you relying on in terms of Section 38? Subsection D and E?
In the public interest, yes, D.
E.
It's D.
D. Public interest, D.
Yes.
All right, thank you.
Corruption Watch does not rely on a right not, as I mentioned at the beginning, we're not only relying on a right in the Bill of Rights, namely Section 33. We'd also rely on the fundamental principle of legality and the rule of law. It can hardly be denied that this application is genuinely brought in the public interest on the test postulated by O'Regan J. in Ferreira versus Levine. The courts play a crucial role in our constitutional democracy, and the JC's function in recommending appointments to the judiciary. And we've heard already how the Constitutional Court has described that as being of singular importance. The designation decision that's impugned in the review affects the broader public. The application in Part B is a general and prospective application, and there's no reasonable or effective manner in which the challenge can be brought other than in these proceedings. The question then is whether Corruption Watch is entitled to claim this court's time and put the opposing litigants through the trouble of this litigation, and we submit that the answer is a resounding yes. The interest asserted by Corruption Watch is neither hypothetical, it is real, it is true, it's not academic, it relates to a real and practical situation, and the injury claims to suffer is the rights to just administrative action and the undermining of the principle of legality. In any event, the court has recognized that there may be cases where the interest of justice or the public interest might compel a court to scrutinize action even if the applicant's standing is questionable. In our final submission, this is plainly an instance where the public interest cries out for the relief sought. Those are my submissions.
Yes, before you sit down, Dr. Hlophe, in his papers, has continued to assert that he did nothing wrong. He followed a practice which judges do engage in, of discussing cases and so on, and that's all he did. Now, to the extent that he pursues that and alleged that I've got an application at the Constitutional Court pursuing still his innocence and an appeal at the SCA, I know that those matters may have fallen away. But he says that this whole issue about his being a judge who has been removed and therefore unfit is not closed yet. What's your views in that regard? Of course, he was using those cases, but we know the one case has lapsed and the Constitutional Court has dismissed his application for direct access. But he has made that assertion that, look, this matter is not closed yet. Can this court have then a debate about what has happened when actually it's known that he has been removed and so on?
No, my lord. It remains a binding decision until it's been set aside. There are no pending applications that we are aware of that are challenging it. There's no concern regarding a possible contradiction between the finding between this court and another. And if anything, this demonstrates why there's a concern regarding Dr. Hlophe's designation to the JSC. This is a person who remains unrepentant, a person who questions the integrity of the very institution's processes.
Yes. And of course, there's a question of him having referred to some practices in foreign jurisdictions. Any comment on that?
We've set that out in our heads of argument very briefly, that they provide no assistance. They are distinguishable from the facts that we're dealing with here. And I can direct your lordship to the relevant paragraphs.
Yes, no, we are aware of this. You do need.
They provide no assistance. And one can't transplant simply examples, foreign examples, which one are distinguishable. without having regard to our own constitutional scheme and our constitutional values.
Yes, you have addressed individually the examples he makes in the respective countries, and the answer is not applicable.
Yes, sir.
Yes.
Just for sake of clarity, it's on page 1428 that you will find those submissions in order of our heads of argument.
Yes. There's lastly a matter which I have pursued with the other counsel with regard to the other application. Do you have any comment as to which way we should go in your views?
My Lord, I wouldn't want to weigh into that debate other than to say that we're dealing with separate applications. You've heard the submissions, and I don't think it would be appropriate for me to...
You plead the Fifth Amendment.
I do.
Yes, I understand. Thank you for all. Thank you, counsel. Thank you. Yes, counsel.
May I please support?
Thank you.
My lords, my lady, I will stick to time. The court is well aware that the Speaker has opted to abide the outcome of this matter. And as explained in her affidavit, she does so on the basis that, first, there's no direct challenge to any specific conduct on her part. And second, she does so mindful of her function and powers and the duty to act impartially as expressed in the cases that we cite in paragraph 5 of our heads of argument. So, as we know, the Assembly was divided on the question of the designation of Dr. Hlophe to the JSC. It's not for the Speaker to defend the views of some political parties over others. But in addition to the need to maintain neutrality, the Speaker also took heed of the admonishment of the Supreme Court of Appeal in another case involving FUL and the JSC, and that's in footnote 5 of our heads of argument. And there the SCA criticized a constitutional body, the JSC, for opposing a matter through the courts where its members themselves were divided. And Justice Ponnen remarked in that case as follows. He said, the JSC chose to oppose both the application in the High Court and the appeal before this court. This, despite the evident difficulty that the matter had occasioned it, having split 8-6 with one abstention. Moreover, there had been serious dissensus within its own ranks. It is thus somewhat surprising that it resolved to defend the majority decision instead of simply abiding the decision of the courts. And the Speaker made reference to this case in her affidavit. But she doesn't merely abide without more. She has sought to assist the court by describing the events as they occurred, and has provided the court with the Hansard record relevant to the decision and the relevant parliamentary rules for the court's assistance. But, my lords, my lady, if I may address just one submission before turning to the Speaker's affidavit. It's not addressed by the Speaker in her affidavit or in our heads, and that is the question of exclusive jurisdiction. And for the sake of clarity, it is our submission that this is not a case that implicates the exclusive jurisdiction of the Constitutional Court. First, because these matters are not pleaded as such. But second, there is no constitutional obligation specific to the National Assembly that it is said to have failed to fulfill. The Assembly's exercise of public power is subject to judicial review, whether that is a review under PAJA or whether it's constitutional review, in the ordinary course. And the High Court and the SCA should not be deprived of its jurisdiction to determine such matters, as the Constitutional Court has told us in the EFF Nkandla case. It's particularly, I would submit, in a case as complex as this, that the Constitutional Court would benefit from the ventilation of these issues in the High Court and the SCA if needs be. Let me then turn to the Speaker's affidavit. She sets out the debate that took place in the Assembly regarding the designation of Dr. Hlophe to the JSC in some detail. The justices have read the papers. I don't intend to spend time going through any of that.
Yes.
But what I would like to do is to highlight 3 key points that the Speaker has made in her affidavit. And the first is this. The first thing she does is to place the matter in context. This is an unprecedented case because it arises from an unprecedented removal of a judge, specifically in this case, Dr. Hlophe, by the National Assembly. The National Assembly had no cause to exercise its powers under Section 177 prior to this. She attests to the Assembly's position of the proper process to be followed for the removal of a judge, and she asserts that the proper process was indeed followed by Parliament in the case of the removal of Dr. Hlophe, and of course, as we know, in the case of the removal of former Justice Motata. It's the Assembly's position that it acted in accordance with Section 177 of the Constitution, and it did so as follows. Firstly, by considering the JSC's finding against Dr. Hlophe of gross misconduct. That determination is a determination that is appropriately located and appropriately made by the JSC as the custodian of the mores of the judiciary and the body vested with disciplinary jurisdiction over judges. What the Assembly had to do was to consider whether that finding warranted the removal of the judges. The Assembly found that it did, and it ultimately called for the removal by a resolution adopted by 2/3 of its members. And it accordingly made a referral to the President for the removal, and on 6 March 2024, the President removed Dr. Hlophe as a judge pursuant to 177 subsection 2 of the Constitution. So that was the first time that the Assembly was called upon to remove a judge based on the finding of gross misconduct. And that's the context and the background that leads us here. Second, what the Speaker does is she explains the process. First, she says that it is the prerogative of political parties represented in the National Assembly to nominate a member for designation to the JSC. Any political party may nominate members of its own party as they choose. But that does not mean that the list presented to the Assembly is rubber stamped, or that it is an automatic adoption of a list. While in the past, the designation was made by consensus, in this particular and unprecedented case, the inclusion of a nominee on the list elicited objection. It was unprecedented because it was the first time the list was not adopted by consensus. She then explains, and this is the third point, by attaching the record. She attaches the unrevised Hansard record that shows that the Assembly on 9 July 2024, when the motion to adopt the list of the JSC nominees served before the House, was subject to debate. She described the process that was followed with reference to the relevant rules. These rules are to be found on case lines at 5-44, which is where Chapter 6 of the rules are appended, and Chapter 6 deals with decisions of questions by the National Assembly. And then Chapter 7 is appended at case lines 5-53, and that is the chapter that deals with motions. The Speaker explains that the process is guided by these rules, by the general rules of the Assembly relating to a motion placed before the House for a decision. A motion passes by way of majority support by the political parties present. This is, she says, standard practice in Parliament. It's in general an uneventful process. When it comes to the JSC designation, until these court proceedings, a motion of designation was never challenged. It was first time that the JSC list included a former judge who had been impeached due to a finding of gross misconduct. What the Hansard record shows is that opposition to the motion having been recorded in accordance with Rule 109, the Speaker then, on 9 July, proceeded to call for declarations on the vote in accordance with Rule 108 of the National Assembly rules. Subsequent to those declarations, the Speaker announced that the motion had been agreed to, the motion carried on the basis of majority support, as governed by Rules 96B and Rule 96B and Rule 97. Now, these rules give effect to Section 53 of the Constitution. And Section 53 of the Constitution deals with decisions of the National Assembly. And it provides as follows. In section, I won't read, just in relevant part, Justices, it's 53(1)(c, which reads, except where the Constitution provides otherwise, all questions before the Assembly are decided by a majority of the votes cast. 53 subsection 2 states that the member of the National Assembly presiding at a meeting of the Assembly has no deliberative vote, but, and then there are exceptions, to cast a deciding vote where there's a tie, or to cast a deliberative vote where there's a requirement of a 2/3 majority. So the rules give effect to Section 53 of the Constitution, which prescribes how the National Assembly makes decisions. That was the procedure that was followed for this motion. The Speaker noted at the end of the declarations that there had been objections of 3 parties. I believe that is at case lines 5-81. And what is recorded on Hansard is that the Speaker notes objection of 3 parties, the Democratic Alliance, Freedom Front Plus, and the ACDP. If the court looks through the transcript, it appears that there were more parties that did object. I think Action SA did, although it wasn't entirely clear, and Build 1 SA also objected. But it doesn't matter, because at the end of the day, the majority voted in favor of the list, and the list included Dr. Hlophe as a designee. That now is the decision.
Ms. Hassim, you have submitted that the explanation of the Speaker, of course, as is evident from her affidavit, explain that the process for designation to the JSC does not mean that the list must be rubber stamped.
Correct.
You confirm that. And you also state that she has no deliberative role in the discussions of the Assembly, except in the exceptional circumstances
Correct.
you put out. Whilst we appreciate also the step that she's taken, despite abiding by the decision of filing an explanatory affidavit, which is, according to the feeling of this court, has been of great assistance just in elucidating the processes in the Assembly. Just a question that arises from that set of circumstances is, one would say there were 3 red lights, not to the Speaker, but to the Assembly. The letter from civil organizations that was addressed to her initially to say, do not designate Dr. Hlophe for the following reasons. It's a red light. Yes, it did not result in any positive from their side, from those organizations' side, result. But the also common cause factor that was known, especially to members of the Assembly, that this was a unique situation. A judge had been removed and so on and so forth until we reached that point of designation. This was no ordinary person, if I may put it that way. To all the members, they knew that this was no ordinary person. So this was a case that was demanding a stop and think attitude. What do we do here? So I'm calling it another red light besides the letter. But the further red light in the Assembly, when they are deliberating this issue, is the objections that come in the Assembly. That's saying, maybe one of the counsel referred to it, this calls for an ad hoc process, not a reliance on a convention or whatever you call it, the practice that had been adopted, where we expect members to say, this is a different case, let's stop, is this correct, and so on. But you just get what you've got on Hansard, a recitation of endorsements of this, nobody saying, yes, but really this is a different case, this is going to chart maybe a different course, and most importantly, we are dealing with a structure that is not a portfolio committee or a committee of Parliament. This is outside Parliament. And even if you are thinking in terms of separation of powers, this is a structure that affects or touches on that, and we've got to look at it differently. Now, whilst this question is not questioning the Speaker, who is an objective arbiter over the affairs of the Assembly, is the Speaker not called upon to say, wait, not because she's taking sides, but to say, wait, members, honorable members of the Assembly, we've got to think, to advise us. Hasn't she got that role to say, we've got to think, especially because of what she says, that she understands that this did not or was not supposed to be rubber stamped. Just to advise, not to tell them. To say, no, we've got the convention, but shouldn't we think twice? Why did not, or doesn't she have that capacity to advise in that sense?
My Lord, let me start at the end then of your input, and that is that the Speaker does remain above the fray. There are options, and it's probably a question that's better placed to address to the political parties represented in court today. There wasn't a request for whether it was for a division of a vote or for what there was a request for a postponement. So if we take a step back, the matter had arisen for decision. There was a postponement of the tabling of the motion because of this concern that had arisen. It was dealt with in part by the Chief Whip's Forum, and the redacted minutes are in the record. The Chief Whip's Forum, as is evident from the minutes, debated the issue and did not come to an agreement. What was then decided was to place it on the order paper again, but this time in a manner that is different from convention. So the convention wasn't followed. It wasn't just accepting that this is the list and we're going to adopt the list. Mm-hmm. It did actually depart. The Assembly did depart from its previous practice by the Speaker calling for declarations. And that was done in accordance with the rules, and that's what followed. Now, in that debate, in that process of the declarations, the views that your Lordship has put to me were discussed in the debate on both sides. The arguments in relation to the designation of an impeached judge and the propriety of an impeached judge serving on the JSC was exactly why those declarations were called for, and then there were counter-arguments. At the end of the day, and the Speaker doesn't deliberate in that process. At the end of the day, the vote was what the vote was, and the majority carried. There may have been other options, and it would have been for the parties present to activate other options, whether that's calling for a division of the votes or calling for a separate process, but that didn't follow after the initial vote was conducted. So that's what I'll say on behalf of the Speaker. But I do think that the question really is why the other political parties didn't do something more, whether it's calling for a division or another process. It wouldn't have been appropriate for the Speaker to halt the proceedings. As far as the letter goes from the civil society organizations, what the Speaker, and I can only say what the Speaker has explained, and that is that when she received the letter, she responded, and she took the view that it is the prerogative of political parties to nominate any member to be on the list of designees to the JSC, and that she could not prevent that. So the call was to stop the vote. And so she took the view that it would not be appropriate for her to stop the vote because anyone can be nominated. The question of who gets onto the list ultimately must be decided by the House. That was the approach that she took, and then the rest followed. That's all I can say on behalf of the Speaker with regard to that decision. There's no question that this is an issue and an issue that arose that the Assembly hadn't had to deal with before. And so there was, and I don't want to speculate on behalf of the Speaker. I can't do anything more than what she has chosen to say in the explanatory affidavit. But the expectation, as I understand it, is that the process that would follow would deal with the complexity which either it failed to do or it didn't fail to do, depending on which side you are in this matter.
Yes.
The Speaker's position before this court is she welcomes guidance on this, and she awaits the outcome of the court decision in this matter.
Yes, thank you, Ms. Hassan.
And as far as costs go, none of the parties are seeking costs against the Speaker. This is not a case in which, particularly given the Speaker's stance before this court, in which costs would be appropriate.
Yes, are those your submissions?
Those are our submissions.
Thank you, Ms. Hassan.
Thank you.
Yes, Counsel.
Thank you, my lords, my lady. I'm going to ask the court for an indulgence for 3 reasons. The indulgence will be to have a little bit more time, as I foreshadowed in chambers. And the 3 reasons are: 1, the amicus is gone, so I can have some of his time, which is allocated. I made that point to the court. 2, our learned friends have been very generous in keeping their arguments relatively shorter than expected. But 3, which is the important point, I feel quite alone here. And I don't say that with humour. Everybody, that's the DA, Corruption Watch, Fool, MK, Dr. Hlophe, the Speaker, say that this court has jurisdiction. We, in the lonely corner, say this court doesn't have jurisdiction. It's a lonely position to be, and I need time to explain. Let me start off by saying the African transformation movement is here for one...
Just 1 minute, Counsel. Because there was the issue from both who asked double divide the time that the period of time. So I was acceding to that and adding half of it. Yeah, Louis got time from from 1530. Gave me 45 minutes. Yes. You give him half of what? From the half from the system. He's getting what if you give him 45 person work. No, that was half of 15. No, it was good to go to the other one for half an hour. So it took it 15 minutes. It is 1 hour for him. 45 it was okay. Received in the initial price of 15. Yeah. Counsel, yes, we have considered the matter. You will get half of the time that was named, which actually gives you from 45 to an hour. 45 minutes to an hour.
I think you'd originally given me 45. And I was asking for an extra 15.
Yes, we've given you 15.
Thank you. Let me start off with why we're here. When I say we, I mean my client, the African Transformation Movement. We're here because we submit that the rule of law is dominant and there is nothing to counterbalance that. I know in some of the papers there's a suggestion, well, the rule of law must take besides the interest. No, the rule of law is dominant. The rule of law includes separation of powers as a key principle. Leave aside Bill of Rights, leave aside national, provincial, municipal autonomies, separation of powers between the executive, parliament, and this court, and the courts. Now, what the relief that is sought, we would submit, cuts across those principles in a number of respects. That those applicants are seeking the courts to intervene in what our learned friend for the Speaker just said was a vote. It was a deliberative decision by Parliament to vote in a particular way. It wasn't some random rubber stamping. And let me just say, if it was a rubber stamping, there's a further problem. Because in the rubber stamping passed back suggestion by the leader of the full team means that all 6 members who were designated by the National Assembly were rubber stamped into the JSC. So it's not just Dr. Hlophe, it's all 6. If the court upholds the rubber stamping argument. And obviously the court's not going to find that 1 rubber stamp was bad, whereas the other 5 rubber stamps were good. Rubber stamping is bad, full stop. So that's a bad argument for the relief that fools seek, for what the DA seek, and for Corruption Watch seek, as a matter of principle. But let me turn to why I submit that this court does not have jurisdiction. 167(4)(e) says clearly in the Constitution, as part of the rule of law, certain courts, or 167 generally, which is the chapter on judicial, the whole chapter, some courts have jurisdiction to do certain things, the High Court can do certain things, the magistrate can do certain things, which the High Court, whatever. But one of the things is only the Constitutional Court can do certain things. That's set out in 167. 167(4)(e) says it is only the Constitutional Court, I emphasize only, that can scrutinize whether Parliament fulfilled its constitutional obligation. Fulfilled its constitutional obligation. Let me just stop. There is a difference between an obligation, the exercise which must happen, and an exercise of a power which is not required. And I heard our learned friend from the DA say, Parliament was required to designate those 6 members. He's right. It was an obligation on Parliament to designate 6 of its members to the JSC. And if it failed to do it lawfully or properly, it failed in that failed to fulfill that obligation. Now let me just turn to a point that was debated where Justice Darfur made the point on Passant that he suggested, well, doesn't one of the parties say the JSC must sit as a whole? And it was us who took the point, 27.135 on case lines, where in paragraph 35 the JSC, well, the argument by, one of the arguments by the JSC was rejected by the SCA. And what the SCA says, acceptance of counsel's argument would mean, for instance, that matters relating to a specific High Court be determined in the absence of the Judge President, etc., in the Premier. And then the important sentence for this Court's purposes goes to this interim interdict issue. What is more, SCA, I believe it is clear from 178 of the Constitution that the JSC has been created in a structured and careful manner. Its composition obviously sought to ensure that persons from diverse political, social, and cultural backgrounds representing varying interest groups would participate in its deliberations. So all the members of the JSC, whether designated by the President, the law professors, the National Assemblies, must be there. And if they're not there, if they aren't there on the 7th of October, then the JSC is not properly constituted, according to the SCA.
Which paragraph are you reading?
35, second sentence. That's case lines 27 and 34. Now the question then becomes, well, it's a very serious matter we're dealing with. Whether the JSC is sitting on the 7th of October to determine, for example, who's going to be the Judge President of this division. It's a serious matter. The whole 4 judges, 4 persons are going to be maybe recommended to the President to sit in this division. Were one of the National Assembly designates, after a vote by the National Assemblies, not be there because he did whatever? That's a serious matter. And the question is, should this court be involved in that serious matter at this point? And for that proposition, let me turn to what the Constitutional Court says about exclusive jurisdiction in our heads of argument, case lines 18-12, paragraph 37. And as I asked the court to turn to it, I just want the court to think of it like this, if I may. For exclusive jurisdiction, there are sort of 2 worlds. There's a world in which there is exclusive jurisdiction to the Constitutional Court, and there's another world where it's not something that falls within the concern. There's a world, but it's not like there's a black or white, but there's a grey area. And courts must decide which of these 2 worlds a particular challenge fits into. Is it an exclusive jurisdiction, which I mean this court doesn't play a role, or is it one where other courts can also play a role? And let's see what the Constitutional Court says about how it is determined into which world the particular case falls into. 1812, in Doctors for Life, the Constitutional Court says in paragraph 24, the principle underlying the exclusive jurisdiction under the section 160 is that, these are the words, disputes that involve important questions that relate to the sensitive areas of separations of powers must be decided by this court only. Let me repeat that. Disputes that involve important questions, it's clearly an important question. Does it relate to the sensitive area of separation of powers? Of course it does. A court's intervening in a matter that was voted on by the National Assembly and saying, National Assembly, you acted irrationally. That touches at the heart of separation of powers. Who must decide it? Only the Constitutional Court, the Constitutional Court says. And it goes on. Therefore, the closer the issues to be decided are to the sensitive areas of separation of powers, the more likely, that's my word, it is that the issues will fall within that section, 167. It follows that where dispute will require a court to decide a crucial political question, what can be more political in this case? And thus intrude into the domain of Parliament, the dispute will more likely be one for the exclusive jurisdiction of this court. And I add paragraph 26, where the obligation, and the court will recall, I've made the point that it's an obligation, and I'll turn to the distinction between obligation and power, requires Parliament to determine in the first place what is necessary to fulfill its obligation, a review by a court whether that obligation has been fulfilled trenches on the autonomy of Parliament to regulate its own affairs and thus the principle of separation of powers. We're in that world.
Just Mr. Katz, there's a view that says the nomination by the MK party of Dr. Hlophe to the Assembly was a political decision, and there seems to be no real dispute about that. But that the then designation decision is not a political decision. It is an exercise of power by an organ of state, which then demands the kind of deliberation that has been suggested to varying extents by the parties here. So when you refer to what you've just referred to now, you're referring to political decisions. And my question to you, well, the suggestion is this what you were talking about here is a view that says that is not a political decision. What's your comment?
We have two submissions, Michael. The first is one submission, but on two levels. The first is everything that the National Assembly does is political. Everything. It's a body made up of political parties representing our interests. It's political, it's an exercise of public power as demanded by through politicians, of course, but that's on the first level. So as a matter of principle, everything the National Assembly does is political. But when it passes an act, when it passes a resolution about what's going on in some other part of the world, it's all political. Everything it does is political in that sense. Of course it's exercising public power, but still an exercise of public power with the aura of being political. When a judge acts without fear, favour or prejudice, nothing political about that. When the President acts, depending on the nature of what position as head of the National Executive or in some way head of state, it might or might not be political. That's an issue. But when Parliament acts, political, that's the first issue. Although that's the first level of the argument. The second level, in this case, there's nothing to suggest that when the National Assembly accepted the, let's call it what your Lordship puts to me as a political decision by MK, it did anything other than consider it and endorse it in the way that it did. The vote could have gone the other way. It was a political decision. So if the vote had gone the other way, and there was a vote, division wasn't called for, all the political parties, including my client's party. My client is the party. None of the political parties called for a division, which means that the votes are, I think the court knows, that the votes are actually tallied person by person to get a number. That's what happens. You ring the bell, everybody goes out, they come back in, and you know exactly what the numbers are in Parliament. That didn't happen. But there was a vote. And the vote went one way, could have gone the other way. Political decision. Happens every day of the year in Parliament. Unlike what courts do. So that's the first proposition, the second level of that proposition. I just want to turn to another aspect of this debate. I find it ironic, and we made the point in our heads of argument. In this court, I, acting for the ATM, brought a case against the Speaker for not having a closed vote in a motion of no confidence against the President. The Speaker in this court took the point that we were in the wrong court, we should have gone to the, let's say we, it's Mahmoud and I and ATM, should have gone to the Constitutional Court, exclusive jurisdiction. And this court dealt with it in a case called African Transformation Movement versus Speaker, National Assembly and others, 2022 to SA 468. It's that case lines 26-224, 240. And the judge is a single judge, rejects the Speaker's exclusive jurisdiction argument and upholds our argument that it wasn't an exclusive jurisdiction point. It's kind of ironic the other way around. But the important point of the case is this. In doing so, the court reasoned why this court does have jurisdiction. That reasoning, we submit, will tell this court that this court doesn't have jurisdiction. That's exclusive jurisdiction. Let me explain why. It starts on 26. And remember what happened in this case on it's page 26241. There's a preliminary issue. Let me just remind back. The court upheld my argument that the court did have jurisdiction, but it rejected me on the merits. Then the case went to the SCA, and the Speaker abandoned the exclusive jurisdiction point, and we won on the merits. But the point is, on page 241, and just above the letter, well, above the number 2, letter here, the preliminary issue jurisdictional point. And you will see, my lords, my lady, the Speaker said up front that this court has no jurisdiction to hear this application. As a consequence, this point eliminates dispositive of the claim. The Speaker could, in this case, about whether the National Assembly, as one of the two houses of parliament, fulfilling its constitutional obligation to hold the President to account, etc. In the Speaker's view, this case is also about whether the National Assembly has achieved its obligations to allow Parliament to exercise their right under the Constitution to vote on the President or not. And it goes on, there's about 3 or 4 pages describing all the cases dealing with exclusive jurisdiction. And I just want to read the last paragraph. It fits into the notion on this point. That's paragraph 25 on 26243. 2 paragraphs. 24. In the same way, I'm of the view that 1 or 2 of the Constitution, that's motion no confidence section, does not endow members of Parliament with the constitutional obligation envisaged in 167(4)(e) to perform a specific act or function, thus triggering the jurisdictional exclusivity of the Constitutional Court. Let me repeat that. The High Court found that a motion of no confidence debate doesn't trigger the obligation to do whatever was being called upon. Yeah, we're not in that world. They have to do it. And if they don't do it, as I've read to you from the SCA, the acting chairman of the JSC versus the Cape Bar Council, you don't have a JSC. They have to do it. And if they don't do it, they're not fulfilling a constitutional obligation. And then it goes on to 25. To this end, I agree with the views expressed by Jafta J in his dissenting judgment in Mazibuko, that's Mazibuko versus Sisulu NO, where he stated that a 102 motion of confidence does not impose a duty on the Assembly to perform a specific act or function. 102, that's the motion of no confidence. It comes if a political party raises the issue. Instead, it confers powers on the Assembly to pass a motion of no confidence in the President if the majority of its members support the motion. The learned judge found in that case the alleged failure to make rules does not give rise to a claim falling within exclusive jurisdiction. We're in a different world. That's why I say we have these two worlds. There, Parliament was exercising a power, no obligation to do whatever under 102. Here, there's an obligation. Anoint six, designate six of your members to the JSC. Now, the respondents say, well, I don't come home on this point because they've pleaded it differently. In our heads of argument, we make the point that it's not how you plead that counts. And if I may turn to our heads, 18-9 of our heads. In Misconduct, which is the leading case, or at the time was the leading case in exclusive jurisdiction, in paragraph 17, this is what the Constitutional Court said. An interpretation of section 1674E that is cognizant of the imperative not to unduly deprive these other courts of their constitutional jurisdiction would be loath to assume this court has jurisdiction. And here's the important words. Even if pleadings state strongly or clearly that the President or Parliament has failed to fulfill the constitutional obligation. The point that they make is this. You might have a pleading, an application with an affidavit, and the affidavit says the President or Parliament or whoever it is failed to fulfill a constitutional obligation. That's the pleading. Strongly and clearly. That's what the Constitutional Court says. That pleading doesn't give rise necessarily to exclusive jurisdiction. You look at the substance. What are they asking for? It's objective. They're asking that the National Assembly's vote failed in its obligation to properly designate 6 members to the JSC. That's what they substance of what they're asking. That's why we're here. By choosing one member of the 6 who they say was not suited to be on the JSC. That's what we're about today. However they may couch it, however they may plead it in their notice of motion, which keeps changing, etc., etc., that's what they're here about. Did the National Assembly fail in its obligation to appoint 6 members to the JSC? And if we are right as to what the case is about, just have to read Doctors for Life, we just have to read Misconduct, makes it clear that issue is for the Constitutional Court and the Constitutional Court alone. This court should not touch it. It doesn't have the jurisdiction to do so. Like the magistrate doesn't have the jurisdiction to scrutinize certain things. This court, and it's no insult to this court, that's just the constitutional scheme. So we submit on a level of principle, none of the cases get off the starting blocks. And I'll come to the interim relief issue in a second.
Well, you are making your submissions, Mr. Katz, but you listened to one of your colleagues making the submissions very strongly that even if this court, as you submit, does not have jurisdiction over the final relief sought, the court has the jurisdiction to grant interim relief pending an application to the Constitutional Court for that final relief, and that was specifically held in the matter of economic freedom fighters. No. In the matter of the National Gambling Board. Yes. 2000.
Two cases. I'll come to that. I will come to that.
Yes, if you cover that, yes.
I
think it's a National Gambling Board. And
then followed by the UDM.
Yes.
So my Lord, may I turn to the actual relief, the last bit of relief that we now see having changed a number of times, but that's fine. Paragraph 2. In paragraph 2 of the relief, they ask for pending a determination of the merits of the review. Well, then it's a bit of a wobble. Because what they say, either in Part B or the Constitutional Court case. So, and it's important, my Lord, that this distinction. Because what we submit is what the Constitutional Court said in Gambling Board and in UDM, is that this court doesn't have, if the court's with me on exclusive jurisdiction, then this court doesn't have jurisdiction to give an intellect pending a review in this court. What it might have, and I'll come to that, so therefore Part B is a dead letter. The Constitutional Court has turned its face against that. So then we're in another world, which is interim relief pending what? Pending the Constitutional Court decision. That might be okay, and I'm not saying it is, but I'll come to it. But the first proposition, the authorities that I've heard, the Gambling Board case and the UDM case, are certainly not a proposition for the idea that this court, not having jurisdiction in Part B, can give interim relief pending Part B. Doesn't say that, and we don't read it, those cases to say that. That makes sense. How could this court give an interim pending this court's decision when this court doesn't have jurisdiction in the main room? Wouldn't make sense. So then the court must think, well, do we have jurisdiction, that's the word, to give interim relief pending the Constitutional Court decision? And I submit that it would be hard for me to argue against, nobody's raised it, I'll raise it for the first time again in my lowly position, 172(1)(b. May, now what? Conceding, I don't need to concede, I'm going to come to why I submit it's not appropriate in this case. May give this court the power to grant just and equitable relief under 172(1)(b, because even though, and I say even though, there's no 172(1)(a) declarator sought or to be granted, and that's the proposition for those who are school, Ermela, various cases. That's not important for the following reason. Were the court to contemplate giving interim relief, which is just and equitable in nature, as suggested by the applicants, pending the Constitutional Court decision, which may or may not be available to this court, the court would have to consider this. The paragraph 32 of the UDM case, perhaps I should read the factors. I think Justice Dafu, you touched upon it, if I remember. You said, Justice Dafu, isn't that summarized in 32? Now, assuming I'm right on all of these different aspects, you would have to think, is it just and equitable in these circumstances to give an interim intellect saying one member of the six can't sit until the Constitutional Court gives its decision? And you'd have to consider the factors set out, we would submit in paragraph 32, it's on 26959. What it says is, from the foregoing, we would hold that, and there are 5 subparts, and this is the Constitutional Court. So, by the way, the court knows that were you to do it, you would be the first court ever in South Africa to do it, unprecedented, in a serious matter like this. And let's see what are the factors in why you should consider doing it or not doing it. That is giving the interim intellect pending the Constitution. It says, 1, it is not necessary to decide whether the High Court has jurisdiction to grant interim relief, the effect of which is to suspend the operation of national or provincial legislation. B, High Court has jurisdiction to grant interim relief designed to maintain the status quo. The interim relief that you would be granting would not be to maintain the status quo. On the contrary, you would be changing the status quo, and it says, or to prevent a violation of a constitutional right where legislation that is alleged to be unconstitutional in itself, or through action, it is reasonably feared might cause irreparable harm of a serious nature. It's going to be very slow to come to that conclusion in a case such as this. You've heard MK, well, you will hear MK, I presume, at some length, Mr. Hlophe is known for, go on about his clients' rights. Clients, not just MK's clients, all the voters of MK. I'm pleased that we're in a court which hopefully keeps us to our time. He's not listening, so I can get it. But the point is simply this. C, such interim relief should only be granted where, and the important words, strictly necessary in the interests of justice. That is the constitutional standard provided by, and should also apply in cases such as those presently under consideration. D, In determining the interest of justice, the court must balance the interest of persons seeking the relief, that's the 3 applicants, 2 plus 1, we're not sure where full is on that, against the interest of others who might be affected by the grant of such relief. Remember, the ACA said the JSC has been carefully constructed by the Constitution to give effect to political, social, and other interests. And the court giving an interdict would be affecting those kinds of considerations. Is it strictly necessary to do so? It's a very hard question. I would say not. Then it says the interim relief should be strictly tailored to interfere as little as possible with the operation of the legislation, all the more so where the legislation results in. So the principle is this. 1, this court doesn't have jurisdiction on the main case. That's Fool's case and Part B of Corruption Watch and DA. 2, you may well have power to grant interim relief pending not Part B, but power to possibly grant interim relief pending the constitutional application. But when you consider that, it's that relief, if you do grant, must be strictly necessary, narrowly tailored, and all the red lights that Mr. Du Plessis has been talking about for Parliament, we submit, should be flashing to this court. The red lights that Parliament had should be up there. Separation of powers. Am I going to, as a court, trench on a vote by Parliament, by politicians? A political decision. And the court knows our arguments on this. Let me just turn to the remedy and I'll turn to my heads. We submit that ATM, African Transformation Movement, because we've come here as a lonely standard bearer for the rule of law, should not, whether we win, lose, or draw, be receive costs or be ordered to pay costs. We're here as a neutral party which says the rule of law is sacrosanct, there's no balancing, and the rule of law, as I've said, talks to all of the kinds of considerations that I've already mentioned. So the question then is, what do you do with these 3 applications? And it's a difficult question, and we submit that there's various options. And we'll tell you, we'll suggest to you the option that we think is the most attractive, bearing in mind the difficulty. In a sense, I say in a sense, we agree with Mr. Trengrove that were the court to find that it's a difficult case to give final relief, it's probably exclusive jurisdiction, probably not in the best idea to dismiss Fool's application. Because it might turn out that the Constitutional Court rules that it does not have exclusive jurisdiction. And then you would have dismissed Fool's application, which is problematic. So as far as Fool's application, we submit the postponing sine die. Behind me I heard from my friends for MK. Anyway, that's the first aspect. As far as the interim interdicts are concerned, our submission, you certainly shouldn't grant them for the reasons, we call it, in our heads of argument, the red line separation of powers. This court isn't going to tell Parliament on Mr. De Beer's submission, well, take away Mr. Dr. Hlophe, put somebody else in there. Of course not going to do that, because there have to be 6. So if you tell Parliament to get rid of Dr. Hlophe for October the 7th and for April and for whenever, you're actually telling Parliament, go and put somebody else in there. We're not going to do that. We submit. That's, as Fool's head say, inappropriate substitution. There have to be 6. If you take one away, somebody's got to put the extra one in there. And who is that? That's Parliament. You're not going to tell Parliament to do it.
Well, if the court doesn't tell them, is in the presumption that they in any way know they have that option.
They haven't got an option. There's no option. That's my point. The SCA says to the world, there must be the composition. Well, it suggests, and I've read it passages before. It suggests the composition of the JS has been carefully calibrated and tailored to give power to political, social, and other groups in a particular way. And one of them isn't there. It's not the JSC. It's something else. You have to have 6. 3 from the opposition. Can't have 5. So as soon as you say 1 can't be there, it means if a sick person, I've read this, it's paragraph 35 of the SCA draft. It have to be 6. What is more, it is clear from 178 that the JS has been created in a structured and careful manner. Its composition, that 6, obviously sought to ensure that persons from diverse political, social, and cultural backgrounds representing various groups would participate in its deliberation. That means 6. Doesn't mean 5. So if your lordships, your ladyship take 1 away, not the JSC, it's something else. There has to be a number 6. Not like a yellow card or a red card in rugby where the guy goes off for a while and only 14. That's still a rugby team. This isn't how it works. So if there's a referee that starts the game and says, right, 14 against 15, not a rugby match. But if there's a yellow card, red card, no problem. Here, they have to be 6. If the court takes one of them away, it's not a yellow card or a red card. I'm not sure what it is, but it certainly falls foul of paragraph 34. So the point I was making was that were this court to take the view that there's a difficulty with Dr. Hlophe sitting, I was dealing with what was the appropriate order, bearing in mind all these difficulties that I've raised in my ATM hat. The question then becomes, we told you we submit that fools should be postponed sine die, because we don't know what the Constitutional Court will say, and if the Constitutional Court says it doesn't have exclusive jurisdiction, then fool's application should proceed.
Yes, you told us.
Yes, I'll just repeat. So now we come to the other 2.
Yeah.
That's where I was coming to, and then I got converted, sorry.
Yeah.
So the other 2, the question then becomes, what do you do with them if you're with me on the question of exclusive jurisdiction and this question of only in strictly necessary circumstances? The question is, it's a very difficult question. But my submission is, similarly, that the DA in Corruption Watch's applications should similarly be postponed sine die. Because it would be inappropriate to give any relief pending a Constitutional Court decision of the kind that we've gone through in circumstances when this court doesn't have jurisdiction, if you're with me on it, and now they can't get interim relief pending Part B because this court doesn't have jurisdiction in Part B. But now they've got a question: do they get interim relief pending the Constitutional Court application? Now I run into the same difficulty that I ran into in my opposition to Fool, because if the Constitutional Court reject my exclusive jurisdiction argument, then they might be able to get relief pending Part B. Part B then is alive. So it would be inappropriate to dismiss the relief in that sense. I know that sounds mathematically jigsaw puzzles, but that's where. So we say all 3 applications, from our perspective, should be postponed sine die. Let the Constitutional Court deal with this question of the world of exclusive jurisdiction. Very sensitive world, a very difficult world to live in. Separation of powers, the red light that should be flashing before this court. Let them decide the Constitutional Court. And then, when the wash comes out, Fool can have a full go at its final relief. DA and Corruption Watch can have a full go. That would then maybe final relief as well, or maybe interim relief. They can decide then. So let me just conclude. I'll be very quick. To say on this point, we in paragraph 2 of our heads, page 18, case numbers 18-6, we say in opposing the relief sought, and we want to emphasize this. The African Transformation Movement makes no submission concerning the conduct of the Speaker, conduct of the National Assembly, the rights of Dr. Hlophe, and Umpuntu Isizwe, and I should add, any of the applicants. We make no submission. What we're here to do is to show the court, or demonstrate to the court, why the court should tread very carefully in granting any relief of the kind that's on the table today. That's why I'm here. not about the DA, Corruption Watch, Fool, or any of the other parties. It's about the rule of law. That's what this case is about. Now turn to the merits. We essentially align ourselves with the other respondents who are Dr. Hlophe and NK in this sense. We said in our affidavit, the ATM, that this case isn't about what one might feel is philosophically or can't remember the other word, let's call it politically interesting. It's about the law. It might be philosophically, it might have a feeling, a vibe, as the Constitutional Court once mentioned, that Dr. Hlophe shouldn't be there on the JSC. That's not what the case is about. The case is about, he is an MP. Now, some people might not like that. Too bad, too sad. He is an MP, he's sworn in, and once you're an MP, you have that which all MPs have. Some are not better than others. There are 400 of them. Some are men, some are women. Some belong to some political parties with particular political bents, others belong to others. Some have got different pasts to the others. We know, we've seen. Some have been kicked out of one party, gone to another party. Some have been impeached as a judge, just one. But he's equal. He's equal to others qua MP, not a judge. That's finished. That career of his is over for now. He's an MP, he's a member of Parliament. And the question is whether that member of Parliament, despite his checkered history, such as it may be, disqualifies him from that which the other 399 members of Parliament may be entitled to and may have the right to. And the answer is no. His past, whatever it may be, is in the past and remains as it was the day that he was sworn in as an MP. If there was an objection to his past, then that was the time to deal with it.
And if I'm understanding you well, your submission is that his past is irrelevant.
Well, his past
is irrelevant.
Irrelevant to his position sitting as an MP being designated by vote by the National Assembly.
Yes, then you're saying it's irrelevant to these proceedings.
In that sense, yes. His conduct is irrelevant.
That's your submission.
Yes. I don't want to make it in a blanket. I make that submission in the context of the relief that is being sought today.
Yes, but it must be because if it's in context of the relief, it's in context of these proceedings.
Yes, no, I accept that. But let's say, for example, a party came along, and I'm just hypothetically making a hypothetical. Excuse me?
Hypothetical.
Thank you, Malek. It's long. Let's say a party came along and said he was impeached as a judge, therefore he has no right to be an MP. I could not in those...
No, nobody has argued that.
No, that's my point.
Yes.
But if that was the argument,
yes,
that would be different to what we have today. Because that ship is sailed. That's the point that I'm making. If somebody had argued that, then his past might be relevant to that case.
But that's not the argument.
Excuse me?
But that's not the argument.
That's not the argument, so therefore we don't have to worry about his past.
Yeah.
That's the point. His past isn't irrelevant in the broader scheme of the world, but it's irrelevant because he's a member of Parliament and he's being designated qua member of Parliament, it becomes irrelevant in that context. If there was some other case about what he could or couldn't do, whether he could be a member of Parliament, of course his past might be relevant. Depends what the challenge is. This challenge is the challenge to the National Assembly designation. And it's a vote And the National Assembly might have been unwise, they might have been wise, they might have been for good reason or bad reason. The principle is that's what the National Assembly chose. If that happens, the court must see those red lights flashing. Should we intervene, the National Assembly, who does what we as a court think is a terrible thing. Red light. That's all. And we've explained it in our heads, and we don't want to get involved in what he did or didn't do, what the speaker did or didn't do. And we submit that the speaker gave a very useful and we think entirely appropriate explanatory affidavit explaining what happened. There was a vote, and this court shouldn't intervene. We submit in vote. Then the court would have to find, and again it's a pleadings question, the court would have to find the vote was irrational. It's a vote. How do you find that a vote's irrational? You might find that somebody does something, the president calls his friends in and says, who should be the for? That might be irrational. Or the Similani proposition, where the president appointed Similani, and the court found he didn't consider the past. This is a vote. We don't know what's at the head of those 400 people. Some voted against, some voted for. How can 400 people come to an irrational decision in that sense as a piece of law?
Thank you, Mr. Thank you, Mr. Katz.
This is the end of today.
Yes.
Because unless we want to hear.
No. Well, in terms of how we're supposed to proceed today, that should bring us
I don't have a problem to begin 20 minutes or so. I don't know.
Okay, let's begin. Yes, we'll let you begin with the hope that that's going to assist us towards tomorrow.
Yes, I will hope so. I actually don't like arguing behind my friend's backs. Can I be allowed to come in front?
Unless we do it tomorrow.
Yeah, let's say we save time. Just keep in what we have left.
Yeah. It's 20 minutes now.
Yeah, 20 minutes.
Plus.
Mr. Masuko, we would have you know that you have
I apologize.
No, that's
the logistics are a bit.
We'll have you know that you have all of 20 minutes for today.
I have
20 minutes.
20 minutes.
Yeah.
Okay, so then perhaps the best way to use my 20 minutes is to just set out the theory of our defense, both to the DA and its partners, Corruption Watch, and then the FUL separately.
Yes.
There are certain errors that have been made in suggesting that the court should moderate the thinking of parliamentarians in how they constitute the 6 members that they need to constitute. So what I'm going to do is I'm going to deal firstly with the requirements under Section 178 1H. In fact, I'll deal with the requirements under Section 178, which is what Mr. Trencroft dealt with right at the beginning. And then I'm going to also deal with the power of Parliament within the Constitution to design its own rules, to make its own internal arrangements. With that, to submit that there is an autonomy given to Parliament, constitutional autonomy given to Parliament or to the National Assembly to decide how to constitute the 6 members or to designate the 6 members that serve in the National Assembly. And then I will then deal with the absurdities that arise in relation to the interdict relief, which essentially is an interdict that is aimed at stopping Dr. Hlophe from exercising what are constitutional obligations, both as a member of the National Assembly and a member of the JSC. But just to get something off my back in relation to the membership issue. Sorry, in relation to Section 178. Mr. Trencroft spent some time looking at how was 178 designations in terms of 178 are done. But may I make this proposition, and I'll go back to the designations that are done by others. The only qualification that is set out in the Constitution for membership of the JSC, of the Judge President in terms of 178(1)(c), is that it must be designated by Judge Presidents. That's the only qualification. No extra qualification. The only qualification is that he must be a Judge President. And there's an underlying presumption in that. If he is good to be a Judge President, then it's presumed that he's eligible to serve in the JSC. Yeah, that presumption fits in perfectly in there. Similarly, when you look at 178(1)(c) and F for advocates and for practicing attorneys, the presumption must be that when they are designated or when they are nominated, they are fit and proper to serve in the JSC. That's an underlying presumption. You don't have an extra, you don't have a committee meeting where you try and investigate whether an interview of some sort to try and determine, as in the Simelane case, who is my learned friend on my right here. They've been talking about him a lot, but he's here. So just thought they would know that, all the things they say about him. So I'm saying, when you look at the designations that are done by the Law Society or by the advocates, the only qualification is that you must be an attorney you must be an advocate. No extra qualification is required. That's what the Constitution says. You can't start reading other things that your moral turpitude to come into things about, or this attorney